Good morning, good morning, good morning. It is Monday. It's May 22nd. I have some coffee. I'm sure we have some cursey words. I've got a great little contraption that one of the amazing lawners sent me. I finally got to do some mail this weekend as we were doing things because my cup always drips, and it's like a giant like insulated koozie for my Starbucks. Y'all know me so well. So thank you. Here's what's happening this morning. Hello. This morning, we have 3 hearings in Idaho. We have the arraignment, which truly is not a big deal. It's been live tweeted. We are waiting on the feeds. Here's what Idaho does. They allow it to be recorded, and then after the hearing's done, that recording can be transmitted. So we are waiting for the transmission. We are waiting for transmission. I feel like I'm in space. It's so weird. So we're waiting for that transmission. We will do that when we have those transmissions. And once we have them, we will cover the arraignment. I'm going to go through the tweets first so you know what to expect. I have sat in arraignment court for a good part of my life. So people are like, what's happening with an arraignment? The defendant is notified of the charges against them, and then dates are set. That's it. That's all that happens at arraignment. They can plea guilty, not guilty, whatever. And so that's what's happening today. What I'm more interested in, because an arraignment's going to be an arraignment and they're going to set time. What I'm more interested in is seeing what happens at the sentencing, or not the sentencing, apologies, what happens at the scheduling hearing for the gag orders. And there is another motion hearing. I want to know what that third motion hearing is. So these are all now in front of Judge. Let's do a quick road so far before we get into these transmissions. It looks like Court TV is going to get these in just a second. So let's do a quick road so far. Here's a quick road so far. In the Idaho murders case, there were 4 University of Idaho students that were killed. Bryan Kohberger has been arrested and charged with that. Last week, he was indicted by grand jury, not preliminary hearing on these charges. Today is the arraignment on the indictment. So there was a previous judge, the judge that did the gag order. That's at the district court level. This moves up to the superior court level. The judges are split. So the pre-prelim judge is one judge, and then it moves up to a different judge. And I say up because it moves along in the court process to a different judge. That judge's name is John C. Judge. I am going to say Judge every single time because I am delighted by it. I don't know if anyone will delight me more than Judge Newman and bringing the jury, but I am delighted by Judge. So I am going to say Judge all the time. His name is Judge John C. Judge. It's great. So with that, yeah, JJ. Should we just call him JJ for short? JJJ. It's J to the power of 3. So John Judge, Judge, J Judge, Triple J, Flying J, all of it. So Judge is who is presiding over this. The arraignment, we have all of the tweets, so we're going to go to them first. I'm sure you all have already seen what happened at the arraignment, but we're going to go through it. We're going to talk about it, and then we're going to go through the video that is starting to come out. I would really like a clean feed, which will probably be on Court TV's channel, but I'm starting to see other channels with it. So let's just do that first. Hold on. Let me get to the start of the clean feed with the defendant coming in and go there. So with all of that, let's just do that first, and then we'll look at the tweets. All right. I think we should do that. Chat, everyone agree? Great. Everybody's got a lower third, but we are working on getting our own court feeds. So, you know, it is what it is. Okay. Thank you, Miguelina. Court TV is supposed to release it to YouTube. That's what they were told to do. What I hate is when they do commercials in the middle of hearings, because I rather just go to their feed. They're the pool cameras, but they're not even playing for me. So let me try that real quick and see. So give me 1 second while we find feeds. I was hoping that the arraignment would start on time and these feeds would be up before I went live. They weren't, so we are doing that. Here's what we're going to see. Again, an arraignment. I went through the indictment last time. The judge is going to ask if the defendant understands the charges, and the defendant is going to say yes. And then it's going to go to a how do you now plea? We know that this defendant just stood silently and the judge entered the plea and said nothing. So it is what it is. I mean, I'm not shocked by that. So let's go to this feed is, again, very much commercial. So that is not working for me, Miguelina. So I'm going to just go to YouTube and pull them. Oh, perfect. Thank you. You guys, Miguelina's the best. So we were grabbing feeds from the different news outlets. The pool cameras are obligated to release them to the different media outlets. So that's what I'm doing. It's going to start with Bryan Kohberger already sitting in court. He walked in with bailiffs. It looks like he's wearing a vest under his jumpsuit. I'm not surprised. Tensions are going to be high in this courthouse because it is an arraignment on a quadruple homicide and the victims' families are there. And then we'll go to Twitter and we will see what happens. So let's go to this feed. Hopefully sound is good. Y'all let me know. Here, let's actually gain this up a little bit just to start. Let's just start with it loud and then work back from there. How about we do that?
All rise.
There we go. Nice and clear. All rise is because the judge is coming in. You may now be seated is because the judge is there.
Good morning, everybody.
This is going to be a pretty quick arraignment. So don't worry about that. This is going to be a quick arraignment here. Let me make this a little bit bigger. No, I think we're good. So again, waiting for the court to read the things. Okay. This is Bryan Kohberger with his defense attorney, Ann Taylor. I don't know if we'll see the prosecutors in this or not, but again, arraignments are very, very standard. Nothing strange, nothing out of the ordinary. The reason they're trying to get the Zoom up is because they gave victims' families the opportunity, and Kohberger's family, the opportunity to be there in court or by Zoom. For some, it might be easier to watch it contemporaneously on Zoom, not in court. Some don't want to be sitting in court in his presence.
We are now on record in state of Idaho versus Bryan C. Kohberger, CR 29222803. Mr. Kohberger is in the courtroom along with his attorney, Ms. Taylor.
I'm going to gain this up just a little bit sound-wise. This is the court reading that the court is now on the record. Hopefully we will be able to keep the sound moderated this way.
I believe also part of the team is Jay Logston and Elisa Massa, who is participating by Zoom, I believe.
The court is just noting for a record who is in person, who is on Zoom.
Prosecuting attorney. Ms. Jennings is of that office too, Latah County Prosecutor's Office. Also part of that team is Ingrid Beatty and Jeff Nye, both from the Idaho Attorney General's Office. I'm John Judge. If you don't know me, I'm a Latah County District Judge, and I'll be presiding over this case.
Judge.
So, Mr. Kohberger, you've already heard a lot of what I'm going to tell you at your initial appearance.
Yep.
But I'll repeat it to you because it's important, and I want to remind you of these issues. So I'll briefly cover your rights, the charges against you.
The judge's audio is very quiet.
Penalties if you are found guilty or if you plead guilty. So I'm going to start with the rights. You have a constitutional right to have an attorney represent you throughout these proceedings. If you cannot afford to hire a lawyer, then one is appointed at...
I think that's as loud as I can get the judge. I realize I'm going to be louder than the judge, but I gained this up as much as we could so you can hear the judge tell the defendant his rights. This is standard and happens in every criminal case.
Public expense, Ms. Taylor and her team have already been appointed, so that's taken care of. You have a right to a speedy and public jury trial where the state would be required to prove every element of each charge against you
Right to an
beyond a
attorney.
reasonable doubt.
Right to a speedy
At
trial.
that trial, you would have the right to cross-examine the witnesses called against you.
Rights at trial.
That means to see, hear, and question them, to call witnesses to testify for you, and if you choose to testify in your own defense. But you're not required to testify because you also have a right of silence. That right is protected under the Idaho and federal constitutions, so you can remain silent throughout these court proceedings, and that can't be held against you in any way. What you do need to remember, though, is that anything you do say, other than to your lawyers, could be used against you in a later
Right against self-incrimination.
court proceeding. Do you understand that?
Yes, I do.
Okay, thank you. You also have a right to appeal any final decision of the court. In order to exercise that right, you need to file a notice of appeal within 42 days of that final decision, or that right is waived. Also, if you are not a United States citizen, any finding of guilt in this state could have adverse consequences to your
They
legal
always
status.
advise of immigration
Do you understand these
consequences.
rights?
Yes.
Any questions about
Part of the
rights?
consequences.
All right. Thank you, Mr. Kohberger. So
He understood his rights. He
let's
had
go
no
to
questions.
the indictment.
And then they read the indictment.
Do you have a copy of the indictment in front of you?
Yes.
Okay, thank you. And you see in the heading your name there. Is that your correctly spelled complete name?
Yes, it is.
Verifying
Is
that
that
it's
the
him.
correct birth date underneath your name?
Yes.
Are those the correct last four digits of your social security number?
Yes.
All right, thank you.
Okay.
All right, I'm going to read you the charges on the indictment, starting with count 1, burglary. That is a felony under Idaho Code Section 18-1401 and 1403. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho,
This is
did
the burglary
unlawfully
count?
enter a residence located at
Burglaries count
1122 King Road, Moscow, with the intent to commit the felony crime of murder. Count 2,
He's not going to plead to each count.
murder in the first degree.
And then these next
That
four
is a
counts are
felony
all
under
murder
Idaho Code Section
for each
18-4001,
victim.
4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died. Count 3, murder in the first degree, a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Kayla Goncalves, a human being, by stabbing
Not Kayla.
Goncalves, from which she died.
Your Honor, I pronounce everything wrong. I understand and feel you. This is, though, a very high-profile case, and the victims' families are going to be in the courtroom. So I would read the indictment ahead of time and maybe watch some. Maybe the court wants to be careful about watching any media in the case, but maybe ask the prosecutors. This happens a lot. Prosecutors, especially in a high-profile case that's being videoed, aren't going to jump in and correct the court. But if there are difficult names to pronounce, sometimes the prosecutors will tell the judge, This happens all the time, but in murder cases, you try to make sure, especially when the victims' families are in court, that the court is aware. You can tell the clerk, and the clerk can let the judge know. So, for all of you asking questions, I see them. I'm grabbing them. We're going to get to questions in a bit. We've got 3 hearings today.
Count 4, murder in the first degree. That's a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. Alleging that you, on or about November 13, 2022, in Lake County, State of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Zana Kernodle. Excuse me. This is hard. I'm sorry. Dana.
At least the judge acknowledged this is hard, but the judge has had this indictment for a few days. If the judge was confused about how to pronounce Zana or Kaylee or Goncalves, the judge could have asked the prosecution. It's completely proper to do.
Zana Kernodle, a human being, by stabbing Zana Kernodle, from which she died. Count 5, murder in the first degree. This is a felony.
Don't disagree, he's probably nervous.
Section 18-4001, 4002, 4003.
You can definitely hear the sniffing in the courtroom.
This alleges that you, on or about November 13, 2022, in Lake County, State of Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing Ethan Chapin, from which he died. This is signed on May 16, 2023 by the presiding grand jury. So now I'm going to go to the maximum penalties of each charge, starting with
death,
1,
or life.
Burglary, minimum 1 year, up to 10 years in imprisonment.
That's the burglary.
Up to $50,000 of both fine and imprisonment. Restitution for the victim's economic losses resulting from the crime. For counts 2, 3, 4, and 5, murder in the first degree, maximum penalties, life in prison, or the death penalty.
Yeah,
Fine
death
up to $50,000
to life.
for both fine and life in prison or the death penalty. Restitution for the victim's economic losses resulting from the crime. Also, additional fine of up to $5,000 to be paid directly to the victim's families. If you are found guilty or plead guilty,
He's going to read this for each
charge,
one.
and the maximum sentences are imposed consecutively, that means one right after the other, you could be facing 10 years in prison, followed by 4 consecutive
10
life
to life, to life,
sentences
to life,
or
to
death
life.
penalty, fines of up to $200,000 and $20,000 to be paid directly to the families with any restitution resulting from the crimes.
They can charge him restitution. I don't know how he would ever pay it.
Okay.
We'll go over the burglary charge when this is done.
Mr. Kohberger, do you understand the charge in count 1, burglary?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 2, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 3, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 4, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 5, murder in the
Yes.
first degree? Do you understand the maximum penalty?
Yes.
Okay, Ms. Taylor, is Mr. Kohberger prepared to plead to these charges?
Your Honor, we will be standing silent.
Okay, because Mr. Kohberger is standing silent, I'm
This is a procedure in Idaho. This is not an option in California. You have to plead one way or the other. Normally the attorney can do it, but sometimes oftentimes the defendant does it. Standing silent means the judge is going to enter a plea on his behalf. He is not going to plea one way or the other. So he is not entering a not guilty plea. A not guilty plea is being entered on his behalf.
I'm going to enter not guilty pleas on each charge, counts 1, 2, 3, 4, and 5. Now, at this juncture, the state has 60 days to give notice of intention to seek the death penalty.
That's an important date. So a lot of you have asked and will ask coming in the future, will the state be seeking the death penalty? Is the death penalty an option in this case? The state has 60 days to make that decision. So they will have to give notice to the court and the defendant if they're choosing to seek the death penalty one way or the other. The court has entered not guilty pleas.
And
there is a 6-month speedy trial.
Constitutional and statutory right to a speedy trial.
6 months.
So let's start with you, Ms. Taylor, and then Mr.
He is not waiving his speedy trial right.
Discuss some scheduling.
Your Honor, we'd ask the court to set this trial at the very outside of the speedy trial right. We're not prepared to do anything but ask the court to do that today.
She said, we're not prepared to do anything but ask the court to do that today. That means that this will be set on a speedy trial calendar, meaning at the outside of 6 months, but they could choose to waive time if they need it later. Remember, this defense team got over 51 terabytes of data. So they might not be ready in 6 months. I'll answer questions as we get to the end, as we get done. So they are just saying set the date. This date will probably move.
And that will be November.
There's Judge for the first time.
I have not counted it out, Your Honor, but I believe that we did.
She's like, I didn't calendar out the last possible day for 6 months from now. Judge also has a very large chair. I've never seen, in my practice in person, I've not seen a judge's bench be so far over to the side of the courtroom. Normally they're kind of in the middle. He looks like he's just shoved in a corner. It's just odd.
November 22nd is when it's maybe November 20th. So I'd ask the court to set it for an October trial date.
So she's asking for an October trial date.
How long do you think it will take to try the case?
My best
Y'all, we'll
guess
talk about-
is it would take at least.
We'll talk about standing silent in a minute. I want to hear her trial estimate.
My best guess is it would take at least 4 weeks, maybe 6.
4 to 6 weeks for trial. That's probably right. Probably
So
more.
you'd like me to set this for a 6-week?
Probably 4 weeks for the
trial?
state, maybe 2 weeks for
At this
defense.
point, I would, Your Honor.
That seems about right.
Well, and in order to do so, I will have to get rid of some of the other jury trials I have, but this is more critical and more important. So, Mr. Thompson, what's your...
Those trial dates are workable to the state judge.
Thank you.
Yes, the prosecutor does have a Santa-esque beard. I'm grabbing your questions. I'm going to go through them when we're done. The court is probably making notes for the file. Missy P, yes, Judge is the final judge, or should be.
October 2nd, starting.
They've sent the trial date for October 2nd.
6 weeks.
I wouldn't mark your calendars on that yet.
Anything else we need to address today, Ms. Taylor?
Not with regard to the trial setting, no.
Anything else?
No.
Thank you. Thompson?
There are other hearings today. So they are saying nothing more at this time on the arraignment, because the arraignment's done. That's it. That's everything. But this trial date is likely going to get pushed. Though, that's a
So,
strategic decision for the defense.
With that,
It's a hard decision for the defense. We'll talk about that in a minute.
by the way, I do want to let everybody know, if they don't already know this, that once the grand jury issued the indictment, preliminary hearing scheduled to start on June 26th.
Yeah, we know that, Your Honor.
It's no longer needed. And
Yes.
it's vacated. So
Are you telling the
I'm
public?
confused about that.
We all know that.
So I thank
Or at least
counsel.
the law nerds watching this channel know that.
Because
they're smarter than your average
and the public for
bear.
your attention and respect. So we are adjourned. Thank you.
Okay. The arraignment is adjourned. That is it. And Bryan Kohberger is going back into lockup. His attorneys are following him. The prosecutor will probably talk to the defense because they've got 2 other hearings on calendar today. So, and I don't know if the defendant will be present at those. Doesn't need to be for the gag order, might be for the motion. So that is it. Truly, that's the arraignment. They are very quick. They are very standard. They are very normal procedures. So there's nothing that surprises me about anything that we saw in that indictment. So, or anything that we saw in that arraignment. That's just the way that it is. Will we see the other hearings today? I very much hope so. I anticipate that we will. I am waiting for that. So I'm going to keep monitoring other feeds to see if we get those other parts of today's hearing. So my moderators and Miguelina are keeping an eye on that. So we will see. We will see. I know that lots of other channels are playing them, but we will see what happens. I'm going to answer your questions while we wait to see what's going on with these other hearings. Let me get to Twitter real quick. I'm taking a look at Chanley Painter's Twitter just to get a picture inside the courtroom before I go to questions. Bryan Kohberger will be arraigned on 4 counts of murder and the 1 count of burglary. We'll talk about that in a minute. Courtroom is filling up with victim family members, taking up almost 5 rows. There's a row and a half of investigators. It's a lot of investigators. There are more than 50 spectators, media, and public. We all sit here in silence waiting for the hearing to start. Bryan Kohberger entered with 2 attorneys. We saw the new attorney on the latest filings, the male attorney, victims' families glare. Hi. Have a good day. Bye, hon. Dr. B says hi, chat. Kohberger gave a very quick glance to the gallery. I wonder if he was looking for his family. They probably would have told him if they weren't going to be there. If they were or weren't going to be there, I imagine that wouldn't be a surprise to him. Oh, let's see. The judge reads the counts for Maddie Mogan. Mispronounced Kaylee's first name and her family shakes their head. Same for Xana. Kohberger reads along with his copy. The judge's mic is lower. He's not speaking into it. The judge seemed to not have his mic turned on. Kohberger stands silent for the charges. Therefore, the judge has entered the not guilty plea. Defense set a trial right inside the speedy trial right, not outside. So it was right at the end of that 6-month period and set aside a 6-week trial. So different jurisdictions have different rules with regard to no contest pleas, with regard to guilty, not guilty pleas. So let's chat about that real quick. A no contest plea generally means that you are taking responsibility, but you're not admitting guilt. So you are taking a no contest plea to end the criminal process and take responsibility without an admission of guilt, normally done if there are civil cases pending and you're saying I'm not admitting guilt, but I am taking responsibility. That's not what's happening here. Bryan Kohberger entered a not guilty plea but didn't. He stood silent and allowed the court to enter the not guilty plea for him. Is this something commonly done in Idaho? I'm going to have to ask Andrea Burkhart. I don't know. It's not something that's a procedure or process that is available in California, which is where I practiced. But he stood silent, and that is essentially saying, I am reserving my right to say nothing, and the court entered the not guilty on his behalf. People are going to read into this. I can imagine how that's going to go from now. Here's what I see happening on the internet. This is a normal process. The defendant can enter a not guilty plea. The defendant can enter a guilty plea. The guilty plea was never going to happen in this case. The defendant entering a not guilty plea or allowing the judge to enter a not guilty plea is a very normal procedure. Does it affect anything down the line? No. Could this be strategic in that Bryan Kohberger does not want to say the words not guilty in front of a courtroom full of the victim's family? Maybe. Or is the internet going to read into this means he has a guilty conscience and he can't say that he's not guilty because he knows that he has a guilty conscience? I can see the interneting, but I don't think that we can read anything into a normal procedure, which is he is allowed to make the option to stand silent and have the court enter in a plea on his behalf. And since that is a option for him, he and his defense attorneys chose strategically to do it. I would read nothing more into it than that. The court entered a not guilty plea for him, and that's all. That's all. So what else is going on today? There is a hearing on the gag order, which is really just a scheduling to set oral argument, or maybe the judge will remove the gag order. We'll see. And then there's another motion hearing. So we have two other things that are going to be happening. This could be a defense strategy. This could be something that defendants regularly do in this jurisdiction. We will just have to see what comes next, but it's not going to impact him going forward. It's just not going to be impacting anything going forward. He's not admitting guilt. He's not taking responsibility. So there isn't any other kind of plea to enter other than not guilty. Because other types of pleas are accepting responsibility without accepting guilt. So that's the difference. So that's it. If that helps. All right, let's get on to the rest of, well, Twitter. Let's see if that other hearing is about to start. It looks like the scheduling hearing is about to start. We should get a feed of that. After it's done. So that will happen. What else? That's about it. I see you guys giving me the updates from the Twitters. I'm monitoring it too. Hopefully that made sense. I'm going to go through all of our questions now while we're waiting for this. Taylor, why do you say a guilty plea was never going to happen? A, it's too early in the process. B, the death penalty is on the table and they haven't seemed to negotiate anything with the prosecutors. They didn't know until last week that he was being indicted. It's way too fast to have the kind of decision or the kind of discussion you need to have with a defendant if they're going to just show up at arraignment 2 days after they've been indicted or 3 days after they've been indicted and plead guilty to the death penalty. I can't imagine having enough time to go over that with the defendant. I can't imagine a defense attorney allowing that to happen. He has a lot more, they have a lot of time to decide strategically if they want to waive time or not. They were gearing up for the preliminary hearing at the end of the month. So going in and just being like hey, I'm going to plead guilty in a death penalty case is so ill-advised that it is my opinion that that was never, ever going to happen today. Could he take a plea later? Maybe. Would the prosecution take the death penalty off the table? Maybe not. How do you feel if you're the victim's family? I don't know. I don't know if you want the death penalty off the table. So what do you do with that then? I don't know if the prosecution is willing to take that off the table. That would be the negotiation. I don't think Kohberger is going to plead guilty to the judge and then have a penalty phase trial. I think he's going to fight the search warrants, fight the evidence. Also, the defense just got a 51 terabyte data dump. So I don't even think they can properly advise their client on a plea other than not guilty at this point. So I thought a guilty plea was never going to happen today at arraignment. I've seen it happen at arraignment a handful of times. It's very rare. And it normally happens in misdemeanor cases like DUIs, where people come in for arraignment and they're like, can I just start my community service and get my license back, please? Sometimes that happens, but it's rare. And I don't think I've ever seen it on a significant case like this. So, with all of that, let's continue on with your questions. How much does the prosecution factor in the family's needs? Peachy, they don't really factor in the family's needs so much, and this might feel like splitting hairs, but lawyer. They factor in the family's input. But there are lots of times that the prosecutors will do what's in the interest of justice, even if that's not what the family wants. And so it is factored in, but it is not the end all. And I have seen that go both ways. I have seen families that want people prosecuted for much more than they're being prosecuted for, more serious charges and more time, where that's not the just result. And then they are pissed off at the prosecutor. I've also seen the case where victims have come to court and said, I don't want this to progress any further. And the prosecutors are like, no, we're going forward. So it goes both ways. The prosecution, once a case gets to prosecutors, even if victims want to drop it, sometimes the prosecutors don't. They're like, in the interest of safety of the community, we're not dropping this case. So it really, really just depends on the case, but they take it into consideration. They, in a case like this, would have conversations with the family, but they might not always agree. So they will have conversations, but they might not always agree. Lilac Emily, just to let you know, the hearing regarding the gag order is happening right now. Yeah, it seems like it should be starting, and then we should get feed of that, and then the motion hearing should start after that, and then we should get feed of that. I wonder if the judge wanted to let the courtroom clear out. Christine asked, question, if two families want the death penalty and 2 life, what would the court prosecutor do? They would do what their office wants to do. So it would also depend on what the prosecution's office is. Sometimes the prosecution's office has a standard for how they decide what's going to be a death penalty case, what's not going to be a death penalty case, and they will go with kind of their office recommendation. They will go with that. So if it's split between the victims, the prosecution's going to do what their office wants to do. In a quadruple homicide, they may very well want to seek the death penalty. It depends truly on what this office's policy is on the death penalty and what kind of cases they seek it for. Some offices reserve it for particularly egregious cases, and a capital quadruple homicide could count as particularly egregious. There are cases I can think of that might otherwise count as particularly egregious. I'm not going to outline those because it ends up just, there are some things y'all don't want to know, but there are things that ramp up, witness killings, torture cases, killings of particularly vulnerable victims, things like that. So it just depends if a multiple homicide is what this office sees, particularly if they think that this office, or particularly if this office thinks that this was a stalking case. And this, again, this is if this office thinks that this is a stalking case, if they think that these victims were targeted in some way. This is different than a random killing. It's hard to talk about the levels of homicide because for the victim's family, their loved one has been killed, and so there is no level to that. But in the prosecution, there are levels to that. So if there are more facts known to the prosecution that makes this a quadruple homicide, and then we will see whether they choose that. But they have 60 days to choose it. They will not explain to us why they choose it. We know that some of the victims' families want that. We will see what happens. Some victims' families might not. Here's what I can tell you from my experience. I have had cases that were death penalty qualified cases that we did not seek, or could have been death penalty cases where we did not seek the death penalty. I don't know if the victim's family would have felt better either way, because a prosecution and a guilty verdict doesn't bring anybody back. Life in prison doesn't bring anybody back. And some victims' families don't want the weight of knowing that then that person was killed too. Some victims' families are like, live with what you did. Live with what you did every single day. Live with the fact that you will never be outside. Some victims' families are like, no, fuck all of that. Why should you get to live? It really just depends. And those feelings can change as people walk through grief. Grief sucks. Grief at losing someone to a homicide is different. And there's different levels within that. Losing someone in a stabbing is going to feel different than losing someone in a more random crime, is going to feel more targeted, is going to feel different than losing someone in a DUI. It's just all different. And so victims' families are going to grieve in their own ways, but grief in this way is particularly difficult, and there's no right answer. And there's no right answer for the victims' families for what they want. I'm sure what all these victims' families want at the end of the day is for this shit to have never happened, and for their loved ones to never have been murdered. I'm sure that's what they want first. So, California is a death penalty case. They don't seek it as much anymore as they used to, but I did have cases that were cases that could have been death penalty cases where we went for life without the possibility of parole instead, or LWOP. Rachel asked, is the case harder if they go for death? No, it's just longer. There's two phases when you look at a death penalty case. So you have the guilt phase, and then you have the punishment phase. So for those of you that covered or were following the case in Florida, the guilt phase was a plea, and then the penalty phase was a trial with regard to whether someone will get death or life without parole. And so you have two phases, and the jury generally has to decide. So the jury will have to be a death penalty qualified jury. That is a different process. That is a longer process. But the guilt phase is the guilt phase. Then you go to a penalty phase. The things you can bring in evidence in a penalty phase are different than the things you can bring in a guilt phase. The rules of evidence are a little bit different because the purpose is different. You're not seeking to determine if somebody did the thing. You're seeking to determine the aggravating and mitigating factors as to whether that person should have the state take their life. So those are two very different things, and the standards are a bit different. So that's what you get in a guilt phase trial versus a penalty phase trial. Hopefully that helps. Let's get to the rest of questions, and I will keep an eye on what's going on this gag order hearing. It is a scheduling hearing. I don't expect anything to be resolved today at all. Like at all. I expect nothing to be resolved on that, though there is a statement made by Kaylee Goncalves' family. This is coming from Brian Enton's Twitter. Let's go ahead and pull this up real quick, and then we'll go to questions. Let's see. Yeah, Miguelina, we're just going to have to wait. You guys are going to hear me talking to my producer. We're just going to have to wait and see if anybody even bothers to air this scheduling hearing. I hope they will, but we're here. We've got time. We're not doing anything. We didn't even roll the intro today. That's where we're at today. If y'all are new here, go ahead and do the YouTube things. I'd sure appreciate it. My 11-year-old keeps shading me that I'm not a real YouTuber, and I'm like, I'm a streamer. Doesn't it count? No. Statement from Kaylee Goncalves' family. The family would like to thank everyone for continuing to follow this case and keeping the memories of Kaylee, Maddie, Zaina, and Ethan alive. They are what is important, not the defendant, which is hard because these these cases get so focused on the defendant, right? We are thankful that the Latah County District Attorney's Office finally took the case to a grand jury and came back with an indictment. At the same time, we are disappointed that the judicial process has not been more efficient in addressing the gag order. This is just the beginning of a long journey for all the families, and we are thankful for your continued support and coverage. I understand their frustration. Their frustration is going to be their frustration. Talking about it is not going to help. And I know that sounds ridiculous coming from me because I want to talk about everything. I get it. There's no good way to walk through this court process because the court process at the end of the day in the United States focuses on the constitutional rights of the defendant first. It's why different states have started implementing like a victim's bill of rights, but the defendant's constitutional rights will always be considered first because until they are prosecuted, they have especially the presumption of innocence on their side, and those rights need to be protected because there are things that can be done to cause a prosecution and a conviction to be overturned. And that, for victims, is the worst case after the most unthinkable has happened, right? After the unthinkable has happened, going through this process, going through the court system, getting to a conviction, and then having that conviction overturned on appeal years down the road and having to do it all again is very, very frustrating. And I think that is one of the worst case scenarios. So from Brian Enton's Twitter, it looks like Kohberger is back in the courtroom for the gag order hearing. I hate that it's getting called this. Note, hear me, this is a scheduling hearing. Nothing's going to be decided today. This is a scheduling hearing. This is a scheduling hearing. Hopefully we'll have a date and I will cover that when we have a date. Do not make a date while I am at Dave Matthews. Let's just put that out into the universe. Emily has some early tour plans. Nana asked the real questions. Will you be on court TV tonight? I plan to be on court TV tonight, though sometimes TV schedules change. But yes, I will. Look, if you want to stay in the loop with where I'm going to be, especially when I'm covering a case like this, you just need to sign up for Law Nerd Alert until we have our own alert system done. It's getting done. I'm excited about it, but Law Nerd Alert is going to be the fastest way for you to know what I have going on and where I'm going to be and if I'm going to be on TV. I have planes to get to, and we know what happens when I get on a plane. I have short flights. I have really short flights, but I'll tell you what, if this trial goes ahead as scheduled and gets the day it's scheduled is the first day of Vid Summit. If this goes ahead as scheduled, do you know what this trial looks like it's going to bump right into? BravoCon. And for that reason alone, this trial might actually be one that goes on the first date that it's set. Can you imagine? Can we not do this trial and BravoCon at the same time? Like the most travel I have this year is October to mid-November. That might be a reason. That might be a reason this goes forward on time. But, you know, that's me taking the piss because I don't think it's all about me. It's not. This is about this court schedule. All right. Let's go. We can do both. Oh, I'll definitely do both. I will definitely do both. So do not worry. Do not worry. All right. Let us continue with questions. There's lots of questions. Chat requests a nail cam. Well, thank you, mods. Oh, I didn't share them on Insta. We went with like a bright pink kind of concert-y nails. They feel like concert nails to me. So that's where we're at. They felt concert-y. They did. Kylie said, just accepted a job as a criminal courtroom clerk. Whoop, whoop. Remember, you hold the power in that courtroom. The judge is the judge. You protect the judge. You are the gatekeeper, and everyone should treat you with respect. Keep note. Look, I am all for forgiveness, But when you are a courtroom clerk, you keep note of the attorneys that make your life better and the attorneys that make your life worse. That is something that happens, and you let your judge know. It's not gossip when your judge needs to know who's acting an asshole in their courtroom. Trust me. So when I was a research attorney, I would sit in chambers with my judge. I had 2 judges, but I would sit in chambers with my judge. And we would chat. It's like, how are the attorneys? This is the one that's been blowing up my phone. This is the one that's been really easy to work with. This is what this one's doing. This is what that one's doing. And the court clerk would come in and be like, this is who asks for priority every single time. The judges know everything. And their court staff tells them. And if you think the judges don't gossip with each other, have you watched reality television? It's like that. They talk about the attorneys that appear before them. They talk about the supervisors of the attorneys that appear before them. They talk about the other attorneys. The judges know everything. They probably know what level you're on in Bejeweled if you're sitting in their courtroom playing on your phone. Why? Because their benches are up high and they can see you in court. They know everything. Look, they know everything. And sometimes the ones who gossip the most are the bailiffs. They also know everything, and they hear what the defendant has to say when being walked out of court. They know what the defendants think about their own lawyers. They know what the defendants think about the prosecutors. The defendants don't walk out of court oftentimes and shut up. No, they go back into lockup to get lunch and talk to everybody else about the judge, the attorney, and everything else that's going on in court. They know everything. Court would make the best reality TV, except for all of the, very important constitutional rights that protect these sorts of things. But court would make the best reality TV because those chamber conferences, woohoo, the things that people know. Anyway, the judges talk, the clerks are their eyes and ears, and so are the bailiffs. Thank you for the wish of Happy Victoria Day. Happy Victoria Day, Canadians. In the UK, he'd be known as His Honor Judge. I love that. I think we could call this judge His Honor Judge as well. Why did the judge change? Just different courts and different court jurisdictions are set up in different ways. This court jurisdiction is set up so that there is a judge for the pre-preliminary hearing and a judge for the post-preliminary hearing. Not uncommon. This happens in Los Angeles as well, depending on the courthouse. A lot of courts do the pre-prelim, like pre-information or indictment, and then post. So, is Judge related to Tamara Judge? Yes, and it's just all of their opinion. No, I don't think so. I don't think so. Sometimes they waive the reading. How come no waiver here? I think he wasn't waiving anything, first of all. But yes, sometimes most of the time, they waive the reading of the indictment because the defendant knows what the indictment is. But particularly in a high-profile case, they're going to read the indictment. He was not preliminary. There was no prelim. It wasn't a prelimed case. It was a indictment on a grand jury. They're going to make sure that everything is typed up correctly, and hearing the judge read it on the record, sometimes you catch those things. So it also might be part of this court's process. Some judges read all of them, whether or not the defendant wants it. They can be like, we waive, and the judge is like, but I don't. So we're just going to read it. It really just depends on the judge and the jurisdiction. So there's a lot of reasons it could be. Could be a lot of things, but I'm going to keep looking at feeds because once this hearing's over for the that's not what I need. For the scheduling, we should get feed of that as well. So we're keeping an eye on that here. So I'm not surprised there was no waiver of the reading of the indictment here. Is he also acting as a lawyer part of his defense team? No, he's not a lawyer. I mean, he's an integral part of his defense team. He's the defendant. He may or may not have the best information. Like, the defendant should have the best information about the case. If he was there, then he knows what happens. If he wasn't there, then he should be able to say, you know, I was getting liposuction or whatever. Yes, that's a Legally Blonde reference. He should be able to say, this is what I was doing. Let's see. Hey, Emily, did you know you got used in a Channel 4 documentary about Depp v. Heard in the UK last night? I remember that people reached out to ask to use stuff, but I didn't know it was being released. So I knew that people had asked. I just didn't know if it was happening. So if anybody sees that on the interwebs, go ahead and send it to me. If they release it on I don't know, YouTube or whatever, let me know what you thought and if it was good. Hopefully it was. Just a little over 250,000 to go to get to 1 million. I know. And then Griffin can stop shading me that until there's an M, I'm not a real YouTuber. I'm like, I'm going to VidCon. It counts. No, I don't. He'll raise the ante. You know he will. He'll be like, well, until you have a diamond play button. Like, it'll just keep changing. Danny B said you can hear the families crying as the judge reads. You can definitely hear the sniffles in court. And this is the first time that they've really been in court with the defendant in a longer way. And I'm not surprised by that. This is a very emotional thing for them. This is the case moving towards trial. This is them getting closer to hearing what happens. And for the victim's family, it seems that they have not gotten a ton of information about this case, not just because of the gag order. And that happens before the arrest, but after arrest, I think they're really trying to limit any information in the public, which can be very hard for the victims' families because they want to know everything. So there's a balance for the prosecution because the prosecution's duty is to the state, not the victim's family. It's why the victims' families have their own attorneys at this point. Well, some of them do. It's a very difficult and delicate balance depending on the case and the prosecutors. I really tried to keep the victim's family as in the loop as they want to be. And I asked them, there were certain times I asked them to think on things, particularly photos and things like that. I'm like, look, I've done this job for a long time. I go to therapy a lot. You can't unsee things. And so I want to give you all the information that you need at this point. I do not want to give you all of the information that we have because some of it you might not be able to undo. And then that includes letting them know in trial, okay, we're going to do the coroner testimony. And if you want to go, now is the time to go. We will let you know when it is done and you can come back. It was really trying to give the victim's family not just ownership over how they chose to engage with the criminal process, but also dignity. And I think that can get forgotten in a very busy court system, unfortunately. So making sure that victims' families feel that they are being dealt with dignity is a huge part, I think, my opinion, of being a prosecutor. And it should be. And you have to balance that, and you have to balance the rights of the defendant as well. And so that is the balance you sign up for. And most days, or well, not most days, some days, everyone's mad at you for it, which is not what I expect to be. There's a lot of times that just everyone's mad. So the victims' families are mad because they want more. They want it to happen faster. They want to move on. The defendant is mad because, well, you're prosecuting them. So a lot of time, people are just mad. Tracy asked, I thought the death penalty was off the table. Not in this case. There are 60 days to make that decision. Bianca said he doesn't have to wear street clothes during these procedures. I imagine the only time we will see Bryan Kohberger in street clothes or civilian clothes, not jail, is in front of a jury. I imagine that's the only time that we will see that, and there is no jury. Jesus said, why is he charged with burglary? Did he take something? So burglary is not just a theft. That can be one of the things, taking something, breaking and entering and then taking. But breaking and entering with the intent to commit a crime. Oh my God, I sound like law school. Apologies. but breaking and entering with intent. So he's being charged with burglary for the breaking and entering with the intent. They're saying he went into the house. This is what this signals to me. I'm so glad you asked this question, Jesus. What this signals to me is that the prosecution wants to prove that he broke into the house with the intent to commit these murders, so that when he went into the home with the intention to do this. And they have to prove what he went into the home to do. And they are going to do that using that burglary charge. So why charge it? Why not charge it? I think that's why you charge it, because you want to make sure that you tell the jury that he went into the home with that intention. And yes, that will get to the first degree murders as well. But that the burglary doesn't mean that he stole something. It's the going in with the thing. So committing the felony therein, the felony being the murders, it counts as a burglary as well. I had some weird burglaries in my day where theft was definitely not what happened in the house. Emily, what is the purpose of standing silent? Can they use it in a mistrial? No. This is a procedure. Look, this is not a procedure where I practice law. Why they would choose to do it, I'm going to default and wait till Andrea Burkhart talks about it. I know she's in court today. She practices in this jurisdiction. She is a defense attorney. I really very much want to hear what she has to say. Is this the normal process in Idaho, or is this a power play? Or is this just I'm not saying a single word more than I have to say, and it could just be that. What we're seeing from Twitter from Brian Enton is that the Goncalves family attorney wants the gag order issue resolved quickly and asked the judge to address it this week. Your Honor. Excuse me, Your Honor. I would also like this resolved quickly. Could we do it Wednesday? I mean, I realize there's a hearing for the Petito laundry case on Wednesday, but Wednesday's good. Thursday starts to get a little tough. Friday, bad. I don't know if the judge will do it this week. We'll see. Question: how does BK standing silent affect the proceeding now and in the future? It means the judge enters the plea and it doesn't really affect it in the future at all. Is this trial going to be televised or no? Trish, you're asking the real questions that everybody wants to know. It's going to be televised in the way that it is now, unless somebody fucks around and the court decides to leverage the find out. It seems that what the court wants to do is have it recorded and then have it shared after the fact. Leanne said, does that mean the jury box is in the right corner? I don't know. I didn't get much of a sense for the layout of this courtroom from what we saw. Maybe we'll get more of a sense for it later, but it would track that if the judge is kind of in the corner looking at the attorneys, that the jury's going to be to the other side of the courtroom. The jury's going to be closest to the side that bears the burden, so the prosecution. So it would be on the other side of the courtroom. The jury could be on the other side of the courtroom to the back corner so that they have a vantage point to see both the defendant and the prosecution table. Sometimes when the jury boxes are right to the side of counsel table, all the heads in the way in a line, it's like prosecutors and law enforcement and defense attorneys, you can't see the defendant. And sometimes some courtrooms are set up so that the jury actually has a better vantage point to see all of the tables instead of seeing the sides of people's heads. So it just depends. I would need to see the courtroom. 51 terabytes must be mostly video files. I think so. And I think 51 terabytes is also probably the data dump, right, of all of whatever's on Bryan Kohberger's devices. We saw in the search warrant returns that were oddly written. We saw in the search warrant returns that there were a lot of devices taken, so it can also be data dumps from those devices as well. Let's see. Brian Enton just tweeted, judge says because the media coalition went to the Supreme Court, it has slowed the process down. The judge is like, nah. My cat's name is Karen. Could he enter an Alfred plea? This is not a Batman thing. This is a federal court thing. And no, not at this point. He's not taking responsibility at this point. He is, Bryan Kohberger is standing by his rights to not incriminate himself and for a fair trial. So right now he is pushing this forward towards trial, which is his right to do. Emily, Any updates on the TikTok lawsuit? That was last week that I covered it. If you missed it, I covered it. I don't remember what day. The mods will remember. No, the mods will look. I covered it last week. We had a new filing. We got to use our new bumper. It was great. But let me see. I don't think we have any response yet from the professor, because this, what was it, the 16th that we covered it? But we'll see. Let me take a look real quick on Pacer and see if there's anything new, because they have a little bit of time to respond, and they might want to take their time to respond. I don't know if they're going to run a motion to kick out the, oh yeah, there's their answer today. Defendant's answer to claim 1. I'll probably cover that tomorrow then. Oh no, this is the defendant's answer. This is what we covered on the 16th. This is not the new answer. This is the answer and counterclaims that we covered. So there is nothing new. So I covered that on the 16th. So that is over there. Welcome to all the new members. Thank you to all that have gifted memberships. B2, you are always so generous gifting memberships. Thank you. And I've seen a number of you gift memberships. I appreciate you. I can see them in the live chat. So thank you. Welcome to all our new members. Question, what benefit could there be to standing in silent instead of pleading not guilty? I mean, the result is really the same. The result is the same. I mean, it's going to cause people to speculate more, right? I don't think it benefits him, because I imagine, and we'll see what the internet speculation is, but I imagine some of the speculation will be he couldn't even say not guilty because he knows he's guilty. I could see that being the speculation. I don't know how this benefits him in any way. It is the same result. He could say not guilty. The judge could say not guilty. It's the same. The result is the same. Quick math, 51 terabytes equals watching 14,000 days, 24/7 of movies. So 3 years nonstop. Yeah, it's a lot of information, which is why I think this trial date could get bumped. Off topic, I have a job interview tomorrow, 3 p.m. Admin assistant. Good thoughts requested, please. Law Nerds will send you all of the good thoughts. They do that. They do that. What's a Batman plea? I was joking because it's called an Alfred plea. Alfred, Batman? No. Too much? Too much? It might have been too much. Is it too much? Is this too much? I don't know if it's too much. Maybe it's too much. Let's see. So it'll be this sentencing hearing looks like it's taking some time. This is the one I want to see the most. I'm waiting for this sentencing hearing to be released. This is the hearing that I want to see. Let's go see if Chanley Painter has tweeted about it. This is the hard thing with breaking news, and why sometimes I prefer to just wait till it's all done. But I also wanted to talk about this. My 16-year-old son prefers you over Mr. Beast. Hey, Sandy, there's got to be some. I don't yell as much. I yell sometimes, but I definitely don't yell as much. Yeah, we'll go check and see what Chanley has had to say. Everybody's in there today. Karen, I don't know. Will I be covering the Richens trial in Utah? Don't know. Have not decided. Do not know. Have not looked. Do you want to see him? Do you want to see him close his eye when the death penalty was mentioned the first time? I didn't notice, but he knows that that's coming, right? Sent you a DM with Bubba and Metter's video from WLTX. I saw that on Twitter. For everyone who sent me the videos of Bubba being the goodest boy, he is living with Blanca. I saw all of those. And Metters is just a sappy dog man. It was kind of funny to see. Metters is just like, these dogs broke this trial. I didn't realize that Metters had been brought into the Murdaugh case so close in time to this. All right, let's go see what Chanley has to say about this gag order hearing. At least we can get a sense for when the hearing is done. And that would be really helpful, because then we will get a little bit of an idea of how long it'll be. So let's see. We see Chanley has the Goncalves family statement. That seems to be the last tweet from her. So that's it. Let's see. Chanley has a few more details, so we're going to go there real quick, and then we'll go look at the other tweets. And again, this is when I'm covering it this way. Then that's how we do it. I can't wait to see this gag order hearing, though. This is what I'm most interested in. Let's see what Chanley has to say. Internet properly. Hearing is over. Kohberger walks out, shackled at the ankles. Now, Kaylee Goncalves' sister, holding her newborn, expressed to the victim assistant coordinator how upset they are that the judge mispronounced Kaylee's name. I can understand that. I can understand that for sure. Thank you to the law nerds that tagged me in this. I get it. And again, the prosecution could have made sure that the judge knew the pronunciations. The clerk also could have. The judge, it really might just be that he was reading and his brain stopped. I get it. That happens to me all the time. So I get it. Let's see if there's anything else. I don't see anything else on this tweet thread, and I don't see anything else new other than the Goncalves family statements. So let's go back to see if there's anything new from Brian Enton and see what's happening. All right. There are. Judge says the AP Media Coalition needs to tone down their challenge to the gag order. I don't know what that means. He could just deny it. Judge. Oh, God, I hate these inline ads. Judge, just deny it. Goncalves family attorney wants the gag order issue resolved quickly. Judge says it's because the Media Coalition went to the Supreme Court. There are two different issues happening in court right now with the Kohberger gag order. The Goncalves attorney wants clarity so he can speak on behalf of his clients. The Media Coalition is fighting for more public information, less strict gag orders. There are two actually different motions, but they weren't supposed to have the motion hearing today. They were supposed to have a scheduling hearing, and it sounds like everyone is just like, blah. We want to be heard. And it seems that the judge is entertaining it to some extent instead of shutting it down and saying, we're going to schedule this for a hearing on this day. I think we're also going to hear this scheduled for a hearing. And I think this judge is going to keep it intact until it's set for a hearing. I think that's what's going to happen, but we'll see. So we will see. I'm going to go look at the court website and see if they've updated anything, but we will, I'm interested to see what happens in the courtroom. And I want to see this video when it comes out, which will be hopefully in a little bit. Tammy asks, why did the judge change? I touched on that a little earlier today. I'll touch on that again. The court is divided into like the district court and superior court level. So it went from the court pre-preliminary hearing before probable cause to the court after probable cause. That's why. It's a normal part of courts that are kind of separated into lower courts and superior courts. That's not odd at all. That's a very normal part of all of this. All right. Let me get to other questions and then we're going to just chat. Barbara said, did they find they have enough evidence to court? I think what you're asking is, did they find they have enough evidence to proceed to trial? And yes, they did that at the grand jury. So the grand jury did the probable cause determination. The grand jury issued an indictment. So the grand jury heard evidence and said, yes, there's enough. This is all the grand jury said. There is enough to believe that the person that you have arrested is the person who committed this case. That's not beyond a reasonable doubt, but there is enough evidence to hold them in custody through a trial. This is not how did we get here anyway? This is not a person that we can't believe would have done this. There is enough here to believe that a crime happened and that the person arrested could be the person that did the thing. So you can go to trial and determine if this person is the thing. So they can determine that. So yeah, that's what the grand jury did. If the grand jury has a low bar, can charge a ham sandwich. They do talk about grand juries indicting a ham sandwich. And death penalty is the highest criminal penalty. How can it be used for death penalty? Are there two phases for grand jury? There are not two phases for a grand jury. The grand jury just determines probable cause. Like I just said, hey, this person is most likely the person, not most likely. This person could be the person who did the thing. And then it goes to a trial to determine beyond a reasonable doubt. And then after you get to beyond a reasonable doubt, then A jury decides whether or not there will be death penalty or not. So it's the probable cause hearing has nothing to do with the ultimate punishment. A probable cause hearing or a preliminary hearing in a murder case is not a different standard than a preliminary hearing in a DUI case or a petty theft case or a, well, not petty theft because it's generally a misdemeanor, but a theft case. It's felony determinations are the same no matter what the case is at that probable cause level. So a preliminary hearing is a preliminary hearing is a preliminary hearing, whether it is possessions of drugs or whether it is a quadruple homicide. So it doesn't change based on the types of cases, if that makes sense, which is why the arraignment is very much the same. It's like, there's an arraignment. There's always an arraignment. Of course, there's always an arraignment. There's always going to be an arraignment, but it's a very standard thing. So I've seen a number of you indicating that Court TV is live. They are premiering the arraignment. We've already seen it. I don't know why they put it out onto their own channel the slowest, but we've already seen it. So let's go look at some more Twitter and then we will go from there. If that helps. Let's see. We're waiting for the gag order hearing. And that's the thing I want to see the most. I'm very interested in the gag order. You can tell. Like, arraignments are arraignment. You spend a day in arraignment court and you're like, if I never see an arraignment again, I'm fine. I very much want to hear the court chat with the attorneys about this. So let's see. The motions to lift this is from Andrea Burkhart over at Andrea Burkhart Law on Twitter. The motions to lift the gag order will be heard on June 9th. Briefs are due June 2nd. The response is due June 6th. Replies due June 8th. The motions to compel will not be heard today. They will be heard on June 27th. Okay, so the motions hearing is done, which is great. So the motions hearing was regarding the motions to compel discovery. That's not going to be done till the end of June. And then that's when the prelim was supposed to be. And then the gag order motions will be heard on June 9th. All right, where will I be on June 9th? Where in the world is Emily D. Baker on June 9th? And we'll cover that on June 9th in the same way we're covering it now. I look forward to hearing that hearing for ourselves once we get it on the feed. So it sounds like they set dates, so these hearings should be wrapping up. So we should be getting the live feeds soon. June 9th. Well, I'm in the lovely state of Tennessee and we'll just be streaming it. It's a Friday. That's okay. We can stream on a Friday. Great. So June 9th. That's what we're doing. All right. You'll be there. I'll be there. It's a week after I'm seeing Dave in Charleston. So we're all good for a June 9th hearing. Good work, y'all. Good work. Good work, chat. Good work. You guys are great. Thank you. You put it out to the universe that we weren't going to interfere with Dave. And we've made it happen. So, no motion hearing today for the motion to compel. And everything got set over to other dates. Okay. Everything got set over to other dates. I'm not surprised. Thank you, Andrea Burkhart. I'll go retweet that if you guys want to follow Andrea. She is a local attorney there. So when I try to go to people who I know, Andrea Burkhart is one of in the internet sense of knowing a person, Andrea is really always thoughtful, which I appreciate. So, alrighty then. Let's go see if, I think she beat Brian Enton to the tweet as well. We appreciate you, Andrea Burkhart. All right. Let's see. Nice of the judge to work around Dave. I know, right? I feel like I feel like we're just well taken care of today. Brian Enton tweeted, judge is not making any decisions today on the gag order. We knew that. It was a scheduling hearing. Everyone knew that. We all knew that. The judge let everybody complain. Hearing set for June 9th to address it. Okay. Also a hearing on June 27th to address cameras in court. Interesting. That's not what Andrea said. That was for the motion to compel. but cameras in court are going to have to be addressed. The fact that Bryan Etten said the court wants to address cameras in court specifically is concerning to me. It is concerning to me. So we'll see. All right. So those are the tweets on the street. I realize I'm on a bit of a delay, but those are the tweets on the street. When we get access to this feed from this hearing, I will go to it. So that's what we're doing today, because we're we're a whole ass streaming. We're just streaming it. Let's answer some questions. Katie is singing, "Where in the world is EDB?" Yes, I thought of Carmen Sandiego when I said it, but after that, Shanna, I'm sorry. YouTube notifications are a challenge. We know this. We are working on our own notification system. So stay in the loop at Law & Order Alert. We are working on one that is an international solution because the text crew is not an international solution. We are literally building our own solution. So if you want to be the first to have access to that solution, lawandorderalert.com, and then I will keep you in the loop. Petition for a DMB Trucktown meetup. I am working on that. So if you guys have suggestions of where to hold such a thing, where there is also alcohol, email me. My email's public, and we'll do that. So, Emily, what's the strategy behind standing silent? Not wanting to say not guilty? Not wanting to say anything more than you have to say? Just wanting to exercise all the rights that you have? There, look, when we talk about the right to remain silent, it only works if you actually shut the fuck up. So it might just be this is a procedure here. We have the ability to do it, so we are exercising the right to do it. And that is it. I'm, again, interested to see what Andrea Burkhardt has to say. Emily is just going to build one that works. Yes. Yes, I am. Yes, I am. Because again, with email delivery can get slowed down. And email delivery can depend on email provider. So we are working on something where we have less touch points between me saying I'm going live and you knowing that I'm going live. That's the goal. Texas meetup too. When I am in Texas, I am working on doing a meetup when I'm in Texas for Vid Summit. So that is what is happening. All right, I'm gonna look for some more questions. I just had a KH. I just had your super chat up and I tried to grab it and I accidentally ungrabbed it. Let me see if I can go back and grab it. Thank you for the super chat and the love to the Larnard family. I think I've lost it. I've lost it for myself. Oh, the humanity. And I apologize for that, but I see it, KH. Thank you for that. And for the love to the Larnards. Given BK's PhD, do you think he is insane enough to think he could commit this crime and argue his way out? I think, look, first of all, Kohberger has the presumption of innocence on his side. I'm going to talk about people in general, not just this person. I think there are a lot of people that feel that they are smarter than law enforcement, smarter than the system, smarter than those who would investigate them. I see this not just in homicide cases. You see this a lot in fraud cases. Fraud cases, if you can't tell, are kind of my favorite. Where people think they can outsmart you and people think that they're never going to get caught. There is a level of hubris there that is different. So you see this across different kinds of crimes. And so do I think someone who would commit a planned, this seems like a planned until we see other information, and I might change my mind. This seemed like a planned and strategized killing to me. So given that, whoever did this probably thought they were going to get away with it. This is different than your like crimes of passion, which can be kind of heat of the moment. Those crimes don't tend to be planned out. Something happened, shit went sideways. Those are very different than a planned out crime. So Do I generally think people who commit crimes like this think they won't get caught? Yes. Do I think people go into, when they're planning out a crime, go into, and when I get caught, this will happen? I don't think people plan to get caught. I think they plan to do it smarter. That's where I think people generally go with this. They plan to not get caught. But again, fraud crimes, you see that all the time. It's like, how do we do it? What do we do? You see the planning, you see the hiding, you see the, and even in a crime like this, we know that Bryan Kohberger, it's been seen that he turned his cell phone off during the period of time this happened. We saw that with Alec Murdaugh. His phone was off during the time period that this happened, or during the time period that the murders happened. It's like, oh, well, the phone's turned off. Right, but isn't it sussy that it's turned off just during this period of time? You think no one's going to think that? People think that. So there's a lot to be said for it, but I think people think they can outsmart. I don't know if for Kohberger, the PhD is the thing. That might have just been an interest as an interest. I don't know. Lots of people study criminology that have no interest in murdering people. Then again, people joke about all the time, like, if you leave your cart in the middle of the aisle one more time, especially at Costco, especially on the weekend. People joke about it. I think obviously the percentage of people that actually intentionally, volitionally kill other people is low. We live in a mostly civilized society, especially in the real world. Online is a little different. It doesn't feel as civilized on the internet, right? It does here because you're law nerds and you're the best. So, correction, both gag order and cameras will be addressed on the 9th, 27th as the evidentiary hearing. That's what I thought. I'm glad Brian Enton issued a correction because Andrea Burkhart had it outright. Sarah, Emily, you need to write a book. I keep getting asked about that. I love Christine from Simply Neological. Criminology and then something to do with statistics as well. She's fascinating. I love her live streams too. All right, questions. Are you watching the VPR reunion? Yes. I might watch it with my neighbor. I have plans for watching it on Wednesday. I'm very excited. But I also want to go out to dinner Wednesday. Like, I have a lot of things I want to do on Wednesday. I have plans. But yes, I'm going to watch the VPR reunion. I'm gripped. Did I watch the finale? Yes. Do I want to watch it again? Also, yes. Because I was busy processing and yelling the first time, so I need to watch it again. So yes. I can't stop talking about VPR. I can't. It's like that scene out of Mean Girls where it's like, I can feel people getting bored with me, but I can't stop talking about Regina George. Me and VPR. My kid is gripped, not my youngest, my teen. My teen views reality TV as kind of like a social experiment. And he's just like, okay, so if he didn't want to be with her anymore, why didn't he just tell her that? And I'm like, right? He's like, that seems kind of weak. And then for her, Rachel, to do this to her friend is weird. I'm like, right? And then he's like, but why does she go by Raquel when she's Rachel? I'm like, I don't know, because she was a pageant queen and it probably felt more pageanty. I don't know. So now, through me, my teen is looped in to Vanderpump. And he's now asking what's going on. So Chad, I'm sorry that now you have to hear about Vanderpump. Nick said, thank you to whoever gifted me my membership. Emily's lives are a safe space for me to deal with my lawyer court PTSD and drama. Nick, court can be deeply traumatic. I've been there. My therapist knows all about it. It is our court system is not perfect. It is a difficult process. I don't know if there's any other process that's better. We have an adversarial system, and that is very difficult. It is particularly difficult for victims of crime. People cannot come and complain to court anonymously. They cannot give testimony in secret. And when you look at the history of our court system and why they did it that way, I get it. It's fucking hard. It can be horrific for people. But I don't know of a better system to get or to try to get to the facts of what happened. especially when it is two people saying, well, this is what I saw happen, and somebody else saying, well, I didn't do that. And you get together the community and say, hey, listen and hear this out. Hear this out. And then you decide. Instead of having judges that do it, trying to fix a jury, now it can happen. But trying to fix a jury is much more difficult than trying to fix a judge who might have financial interest one way or another. Trying to get to a jury of your peers that are chosen by the lawyers to be neutral and just hear out what happened and then sit down together and talk about it and say, who do you believe? What backs up what you believe is a very interesting process. But again, I've studied a lot of court processes. I don't know a better one. So, but yes, it can be difficult. Know that you're not alone. It can be very difficult. Mike said, I bought my sister your new lip gloss collection. I myself do not wear lip gloss. Fair enough. But I have to support my favorite legal commentator. Mike, that is so sweet. Don't worry. We will have other ways to support in the future. I understand not everybody likes to gloss. I love it. Just a sub said, is there a benefit to BK standing silent? He didn't have to say not guilty. I mean, I guess that's the benefit for him. Devin said, my mom got me on VPR and now my DJ James worm with a mustache merch. DJ James Kennedy made that merch with a swiftness, with the swiftness of Lala Kent getting to send it to Daryl merch out, with a swiftness that I have never exhibited in any merch ever. Goals. Y'all, right now I am just waiting for the feed from this gag order hearing to come out. We are going to get a feed from it. It's just not available yet. So when it does, that's the next thing I will cover. The helpful stranger said our system is as good as it gets. When you add emotion into the system, there's always going to be some issues and it'll never be perfect. Humans aren't perfect, so it will never be perfect. But I've generally always understood what jurors have done. If you take a step back and look at it, I've generally always understood, at least like logically, not always emotionally, but logically, I understand why they did that. And I can't say that about every other ruling I've ever looked at from every system. And that, I think, is a pretty good thing. Again, not perfect, never going to say that it is, but I do think one of the best. So I also chose to be a part of that system. So I am biased in that way, even though I can see the flaws in it too. I mean, sometimes you have to work within the thing to see the flaws, but I don't know, again, a better way. So let us continue answering questions while we wait for a feed from the scheduling conference. It sounded like it got a little bit feisty. Peachy said, I absolutely love the new glosses and showed everyone at work the new Lawnard glosses. For those of you that are new, while we are waiting for this, I'm going to just tell you, we have 3. I put my allegations and shade box back there. Look, I put my second play button up over the weekend. It's there. First play button, second play button. I don't know. I feel like I might need to change it a little because otherwise it might get distracting that it's reflecting on me. So I might have to shift it. I've got my Streamyard duck, my second play button for the Quick Bits channel, my allegations and shade, and then my first play button's right there. That might get annoying. But the allegations and shade set is available. The link is in Nightbot and in the description. And this is one of our colors. This is objection. It is fantastic. I love the way these turned out. So this is facts. Where'd hearsay go? I've got hearsay here somewhere. Hold on. I've also got hearsay. Where's hearsay? Here's hearsay. Here's the thing. People were nervous. My mother are people. People were nervous about the purple. Some of y'all might have been nervous too. It is sheer and it gets a little bit pink on the lip. It is not like a holy shit, you're wearing purple gloss. It is a gorgeous, a little bit deeper pink, but it goes a little bit pinky and it varies based on complexion. And I've seen that from a lot of you when you've shared it with me. Some of you are mixing These two, a lot of you are just putting facts over your favorite lip liner or just over the natural color of your lips. So the hearsay looks a bit more fuchsia on the face. So those. And they're great. They don't stick. So the play buttons aren't symmetrically placed on the shelf. I mean, I think they are, but I was trying to not get the reflection of me doing stuff into the play button. So I think they're kind of symmetrical. I don't know. Y'all will have to tell me. Maybe I need to move it over here and move the pens. Maybe it's time for the pens to go and the pens go. So I don't need to rearrange the background right now. Though I'm so tempted to. Again, as we are waiting for the court feed from the gag order hearing, which seems to be over. So court feeds should be coming out soon. Let's go see if Chanley has anything to say. Court feeds should be coming out soon. Chanley has tweeted the Goncalves family statement. That's the last thing I've seen from Chanley. Let's see if Andrea Burkhart updated anything at all. I'll be interested. I'm sure she'll cover this on her YouTube channel later today. Just the dates. It looks like this hearing ended and we're just going to have to wait. I see no other tweets. So we're just going to keep monitoring the feeds until that is live and made available. It seems that Court TV feeds out the feeds to the news networks first before they make them available on the YouTubes. But we will see. I'm going to go look one more place on YouTube to see if we have anything else. Y'all have gotten us on live trending. Thanks for that. So if you are new here, just do the subscribe things. We appreciate it. We're waiting for hearing from, okay, we don't need alligators surfing is not what I'm looking for, Associated Press. I'm looking for this hearing. And I don't see it from them either. So we're just waiting now. And I will chat with you about all the other things. Yeah, wait, alligators, yes. I went to the Associated Press, and the Associated Press, the first video that auto played on their feed were alligators surfing in Florida. Okay. Okay, sure. So we will wait until the court feeds are available. I'm not going to go watch the alligators surfing. Dolphins surf too. It's on the Associated Press's YouTube page. Look, now y'all are making me regret my choice. All right, I'm going back. It is Florida. Let's see. When I went, hold on. Now we're just doing that. It's happening. It's happening. Let's go pull it up. Let's just pull it up. Hold on. This is from the AP. Why not? This is what look, it auto played on their page when I pulled it up. So I was like, what is even happening? And well, this is what's happening. Oh, Alabama. Sorry, not Florida. Apologies, Florida. It seemed so Florida-y that I didn't even see that it said Alabama because it just felt like a Florida thing. so, not Florida. It felt Florida-y. I'm not surprised. He looks happy as hell. He's like, this is the best beach day ever. Nobody's getting in my way. Nobody's on my waves.
Goodbye, baby.
Dolphins do this too. Dolphins are real fun to watch play in the waves. But I grew up in Southern California where watching dolphins play in the waves was not unusual. If I had seen an alligator in the waves, I would have freaked the fuck out. Occasionally saw the sharks. But yeah, that gator's vibing. Totally chilling. Look, he's like, it's just alligators can sometimes be found swimming in the Gulf of Mexico. Yeah, this one sure is. Chilling in the waves. Alligators can tolerate a variety of salinity levels. Yeah. Alligators can survive a whole fucking lot. They're dinosaurs. They've survived everything. Alligators are fascinating and terrifying all at the same time. I remember I think the first time I saw alligators like in real life, like IRL, was in Costa Rica, because I went to Costa Rica before I had been to Florida. I know that seems weird, but you know, California. And I think that's the first time we saw alligators. I was like, holy shit, there they are. Alligators. Alligators are fascinating. That said, I am waiting for the gag order hearing. It looks like WFLA has it. Okay, so somebody has this hearing that just started literally a moment ago on their feed. Thank you, chat. I'm just seeing you all say the video is out. I'm going to go look and see if we can grab a clean feed of it real quick, and we'll go from there. Crocs are not gators in Costa Rica. Oh, I'm sure that I'm wrong. I do remember Reggie at the LA. Oh, no, that's true. The LA Zoo. Well, okay. So in the wild, alligators and shade. In the wild. I meant the wild. All right, let's go see if we can grab this from one other place, because I would love to just grab a clean feed that's not going to get interrupted. Let's see if we can grab one from CBS. And then we will go from there. Let's see. I am not seeing one from another feed. We might just go to the WFLA feed. What's the status of me getting my own feed? I don't have them yet, but I am working on them. So Scorpion said, I've seen polar bears in the wild. That would be absolutely wild. That would be absolutely wild. All right, let's go to the WFLA feed. I really appreciated the CBS feed had closed captioning on it, but I also want to see this hearing desperately. So am I patient? No. Am I going to be patient? No. Do I need a whole ass newsroom? Yes. I need to ask Ryan Hall, y'all, how he does it, because he's got the entire setup. I just need the entire ass setup. Miguelina, thank you for keeping an eye on those. Oh, did you grab one? Yeah, there isn't one. It doesn't seem to be one. That's okay. We're going to grab it from WFLA. Love Hey JB. And they don't break for commercials. So they'll just play the hearing clean, and we will just play it clean. Hopefully we can hear the judge better than the first hearing. Hopefully I'm going to gain this up a little bit, and if it hurts our ears, we can fix it then. Alrighty, let's just do it, y'all. That's not what I meant to do.
Help the ability to find a so-called impartial jury.
This is the gag order hearing. Let's listen in live. Walt will let you go. Thank you so much.
Thank you.
Thanks, JB. Let's hear it.
Okay.
The first thing that happened in this hearing is that somebody's mic was muted.
Open it up.
I'm going to gain this audio up more.
Say something, Mr. Perone. Still, I don't know.
All right, there's Judge. Some of the other... I just fucked it up. Hold on. Sorry, y'all. That was me. As we were watching, I zoom back. Okay, I fixed it. Somebody's mic is muted. And they're trying to fix it. I love the bailiff is just turning up the volume on the TV.
Are your speakers all the way up, Mr. Perone?
You're muted. So you can, I like the way they've got this set up though. It's easy to see. So the nice thing is this is easy to see while they try to fix the microphone problems. The poor sheriff is like, I am not the tech guy. Courts never have tech. And this isn't the court's problem. This is the lawyer in their office's problem. He probably has headphones plugged in. Sir, you're muted. Sir, your mic, lawyers and tech are the worst. If you're interested in going into the field of law and you are technologically inclined, lawyers need you.
People who take care of this.
So now we get a little better feel for this courtroom. Actually, I'm going to let this play and gain it down a little. The court reporter sitting in front of the judge, the court clerk sitting next to the judge. The judge is kind of squished in the corner. But
JB here with you in the stream center. Just wanted to
it also looks like the judge can turn to the jury box.
let everybody know I'm boosting the audio just a little bit so that hopefully
Okay,
everybody
thank
can
you,
hear, but this
JB.
is the raw-
I'm already
boosted
boosted.
a little bit.
This is
out of
JB
Idaho.
talking about the
And
raw
the Gag
feed.
Order Hearing out of Idaho.
Somebody is trying to fix that?
The lawyer's not a cat. At least we're there. Why aren't they there in court? I don't know. They might be from another part of the state.
Masses,
and not able to get there?
Excuse me, can I hear you?
So-
Now? Say something.
This was
Yeah,
meant to
you're-
be a Zoom hearing. A Zoom
What I can
hearing.
do is I can.
This was meant to be a Zoom hearing. So some of the attorneys might have had other appearances in other courts elsewhere in the state and not able to actually physically get there.
Big echo.
It's always a good idea to be in court if you
Honestly,
can
I
be.
am not very skilled at such things.
You go into law because obviously you're technologically challenged and you hate math, but you still need your parents to love you. Isn't that why people go to
Okay.
law school? I
Really
don't math.
sorry for all the delays.
I can't be a doctor.
There were other things going on before I came into court, and now we have this.
What else was going on? Ooh,
Thank
you're
you
on
for
our
your
T.
patience.
What else? Tell us.
Okay, while we're waiting for that, I'm going to recognize Mr. Gray, who's representing
Counsel,
the
did you try
Goncalves,
turning it off and turning it
family.
back on?
My plan was
Did you restart
to
it?
go
Did you log
through
out and log back in?
the variety of motions that each representative has.
I forgot to swoop. Hold on. This is the scheduling hearing for all of you that are just joining me. This is the scheduling hearing with regard to the gag order. So what is expected to happen, and we know that dates have been set, is that they are scheduling the hearing with regard to the gag order. We've seen the motion filings from the Goncalves family, which is one set of motions, and we've seen motion filings from the Associated Press et al. Media. That went up to the Supreme Court. The Supreme Court said, go talk to the lower courts. This is now the lower court judge with Judge, who is going to be hearing those motions. It seems that the gag order is still going to stand until those motions are heard. So let us join with this.
Starting with the Associated Press, then
Two motions.
going to the Goncalves family, and then to the party's counsel, and we'll see where we go. But we're not going to have an 11 o'clock because we're just going to take care of all the scheduling
Great.
issues now in this hearing.
Great.
Thank you, Your Honor. Thank you.
I don't think it's the TV that's the problem. Maybe it is the TV and they just can't hear
Yeah,
the
let's go
attorneys
off
on the
record
TV.
until we can fix this.
So they're going
Thank
off the
you.
record until they have the tech fixed. So we should hear when they go back on the record. I'm going to actually speed this up because we can until they go back on the record. Again. Oh, there's a really bad echo, but at least they're getting something. The judge is in court. So the judge is in court, but also on Zoom with the attorneys that were scheduled by Zoom. This hearing was originally set to be done by Zoom. So I'm not surprised that some of the attorneys are still there. So the judge is in court, but we're seeing the judge on the Zoom screen as well. But the judge is also physically in court. So great. All right.
Fine with me.
So they're going to be going back on the record in a minute.
So I'm going to unmute myself.
The host muted you. Your Honor, you have them muted. You have to mute yourself. Okay. There's an echo.
Okay. Can everybody hear me?
Oh my God.
Yes, Your Honor.
And I can hear you, Mr. Barone. We have echo now.
Oh! We are 3 years in on everyone having to learn to use Zoom,
Okay.
and it is
better?
still a mess.
Oh, brilliant. Thank you, Mary Lynn.
Put in headphones.
Okay. Thank you, Jennifer. Let's get back on the record then.
Headphones. Put in headphones.
Back on the record, State versus Bryan Kohberger, CR 29222805. I was explaining how the
Cheers. We're now getting to the gag order hearing.
order and the scheduling conference might go, at least my plan. And so I'm going to start with you, Mr. Carone.
We did need a
Your
goat.
clients have the motion to vacate the amended non-dissemination order.
The
filed
media
May 1.
defendants. The
Also,
media
motion to
parties.
intervene.
Not defendants,
filed
media
May
parties.
1, same date. And now this case is in my hands, so I need to set a hearing. And I'm wondering how far out. I'd like to get some briefs, and this is a message to everybody before the hearing, including I want to hear arguments about whether or not there should be cameras in the courtroom in a high-profile case like this one.
What? No. Why are you asking? Don't ask. Is there closed captioning on this feed? No. Not at the moment. Sorry. There is not. That's why we were trying to find another feed.
So
but there weren't any other feeds.
Mr. Carone, what looks good for you? And let me throw out, knowing that a lot of you are prepared to be here the week of June 26th, that might make sense.
The judge asked.
I'll hear from you, Mr. Carone.
Yes, Your Honor. So with our motion to vacate, motion to intervene, we briefed the merits issues there. I think as the court's aware, we also briefed those issues.
Calling in from a tin
so
can.
We could be ready to move pretty quickly. We have not briefed the issue about video cameras in the courtroom, so if that's something that you'd like the media coalition to weigh in and
No.
as well, we would need to submit a separate brief on that, but we can do that in the week of the 26th. The 26th itself, I'm not available, but the rest of the week would work.
Excellent. And I'll tell you, the reason that I'm bringing up cameras in the courtroom is because if I address that issue, and I haven't let you all know that that might be an issue, then I'm going to get a lot of grief for not allowing you to brief that issue. So
why
that's
are
why
you
I'm
bringing this
giving
up
an
on
advance
your own?
notice on that. How do you feel about the afternoon of June 27? Given what's happening just quite recently, we might want to do that in person.
This is why scheduling takes time.
Remotely, but then we have to. There are a lot of different.
This is the
interests
judge,
and different
judge.
People who want to weigh in on that, so it might be better to be in person. But
Judge has said, "Hey, we need to hear about cameras in the courtroom, and if the media coalition doesn't get to weigh in on it, y'all are gonna get pissed. So let's just have everyone weigh in on it." And that's what they're going to do. So they are going to hear about the gag order and cameras in the courtroom, it seems, on the same date.
does that work for you? Say starting at 1:30, June 27th, Mr. Brown?
So it's an
Yes, Your Honor, that
afternoon
works for me.
hearing.
Ms. Olson and myself can both come in person. We would have been there today in person, but we found out about the in-person option on Friday, so I apologize for.
So we'll be here in the
We'll certainly
afternoon.
be here in person. If the court's anticipating hearing from witnesses that day to hold an evidentiary hearing, there may be some witnesses that would want to appear via Zoom if that's okay.
We're gonna have a
with the court.
witness hearing?
I'm not sure if that's even something you're contemplating. If I'm just
Oh, boy.
this far.
Well, let me put it this way. It's your motion and others' motions. And one of the complaints that I've seen in the briefing is that there's no evidence in the case supporting any of it.
Right?
You know, we're all kind of moving forward on supposition, I guess. And some of it is obvious, but I think that would be wise. I suppose you could just file declarations, and that's what's been doing.
They could file declarations, then we get to read them.
If we're going to have a lot of testimony, I might want to move this back to 10 a.m. just to make sure that we have enough time to get things finished that day. Would that work for you?
Sure. So our position on the evidentiary issue is, your summary was correct, that we don't believe that there is an adequate factual record at this point. Given that it is our motion and it's based on the record that existed when the order was issued, procedurally, I'm not really sure there is an opportunity for additional evidence to be put forth. I only brought that up because I saw
That's fair.
in Mr. Kohberger's opposition to our motion for reconsideration that there was a mention of an expert witness. If that evidence was going to come forward or other evidence, we of course
It
want
needs to
the
be
opportunity
briefed.
to cross-examine that individual or whatever individuals might be testifying. But as things currently stand for the record as it exists and the evidence that the Media Coalition intends to put forward, we included a declaration with our motion. I'm not sure there's really need for us to put on additional evidence, but if that's something the court was going to hear from the state of Mr. Kohberger, then I just wanted to bring that to the court's attention.
Thank you, Mr. Corona. Of course, you'd have the opportunity to cross-examine any witness. All right.
The attorney,
we'll stay.
the attorney speaking at the moment is the attorney for the Media Coalition that is opposing the gag order, that is asking that the gag order be yeeted. And that attorney is the attorney that took it up to the Supreme Court and is now arguing it again. We covered those motions last week.
1:30 then. So now, Mr. Gray, so I'm thinking that maybe we should keep these things together and do them the same day if that works for you and your clients.
You should.
Well, Your Honor, I see the
agree.
issue very clearly different from the AP's motion versus my motion. I think their motion is more of a getting rid of the
The attorney that is now talking is the attorney for the Goncalves family, who has a separate motion from the Media Coalition.
non-dissemination order, the gag order. My motion is a motion to amend and or clarify some of the issues in the gag order.
Different
We have a lot of
motions.
constitutional different issues that we have. I have some issues that I think are very separate. So I would request a hearing on my own much sooner. I think the court's aware I filed this motion in February on this case, and there was a massive delay based on the fact that the previous judge, Judge Marshall, was waiting for the Supreme Court to get some clarification regarding the AP's motion that she filed with the Supreme Court. So I'm ready to go when the court's ready to go, but I think our issues are very, very different than that of the AP's motion on this case.
Sir, your motion is about almost the exact same thing. The court's, I appreciate you. I don't think the court's going to go for that.
I would request a hearing much sooner within, I can do it by the end of this week.
All right. Well, and I recognize this was all pretty short notice for everybody. And
I understand why this attorney feels like, can we just get going? Here's the background on this. This attorney for the victim's family is saying, look, I filed this motion like back in February when this all happened. And then the AP and the Media Coalition came in and did not file at the local court and took it to the Supreme Court. And then the district judge said, I'm not talking about any of this until the Supreme Court decides. They chose to file it in the district court. They got delayed because of the AP's hearing. So the AP Media Coalition motion bumped the victim's family's attorney's motion back. So I can understand his frustration of, I made this motion in February. It is May. This got bumped because of them. My motion is separate and apart. Can we just please fucking do it now, please? I have been waiting, and that's why this attorney is saying our motions are different. His rights to speak and the victim's family's rights to speak are different and covered by the gag order differently than the media saying we have a First Amendment right to access. They are two different legal issues surrounding the same thing. Does that make sense? Do y'all understand why this attorney's frustrated and is like, but they're separate. Can we make them separate? Your Honor. Separate them. I can understand why. I can understand why he's frustrated. Truly. Because the actions of the other attorneys bounce them back.
I don't know if
you guys have
let me go
questions, drop
back.
them. I'll
Let
grab
me go
them.
to Mr. Rudley and then Mr. Logston, because they're going to weigh in on that motion as well.
They're going to weigh in on all of it because they're the prosecutors.
I'm thinking about maybe June 9th would be the soonest I could do this. But let me go to you, Mr. Logston.
Gentlemen,
we'd be ready to go and would expect to put on an evidentiary presentation.
This is Bryan Kohberger's
To the
attorney.
extent that
Speaking.
Mr. Gray wants to have this motion heard ahead of time, and just based on what I read in it, I mean, obviously.
Here, I've got this sped up a little bit. Let me go down to normal speed. They're talking pretty quickly, and we'll go from there.
If the court were to agree with some of the things that he says,
Into the mic, I guess.
sorry. Obviously, if the court were to agree with some of the things that he says and winds up amending the order, that could change everything for everybody else. So to some extent, I think it actually
Makes sense.
probably better to do them all at the same time, so the court isn't in piecemeal changing what we're all arguing about. But I
There's
would be ready for the 9th if the court.
Two arguments.
No judge likes to do things piecemeal.
Fair.
But I also understand that Mr. Gray and his clients have been waiting for a long time now. It's not anybody's fault. It's just how that came down because the
lawyers made different
Associated
choices.
Press et al. Went straight to the Supreme Court.
And the Supremes
in
were like,
February,
no.
early February. And that would trigger a delay, which it did.
Of course.
And it was important, I think, for Judge Marshall to get the direction from the Idaho Supreme Court before we start, chipping away at each order. I don't know if would you be. I mean, I'm okay setting it for June 9th, Mr. Gray, but you may have some testimony happening. You may want to wait until you hear what everybody else is saying. It's likely that there's going to be some adjustments, you might say, or clarifying in the order. Partly in my reading of the Supreme Court's decision. Maybe I'm reading too much into it, but there were some hints maybe of what the trial court might want to consider. Okay, go ahead, Mr. Gray.
I was going to say, that since this is your gag order now, this non-dissemination order, Your Honor, and in reading my motion, if the court does want to consider making some of the modifications that might have been suggested in my motion, my motion may end up being moot. I think some of my modifications and or clarifications to the non-dissemination order are fairly minor. But allows, and I think the Supreme Court did give some guidance, which I think added weight to my arguments and my motion. So it's not above the court to take a look at my motion as well as any other motions that have been submitted to the court and modify the non-dissemination order, allowing for some of the issues that I discussed in my motion, and then you would only have the AP who are attacking, I think, the gag order as a whole, the non-dissemination order as a whole. I'm just addressing a couple of clarifications and amendments that would allow myself as an attorney to speak on behalf of my clients that regarding the non-dissemination order. And I think it's your order now, so
I think you should go for it. At this point, it's like, look, call your local bar association and be like, hey, what is the guidance on this? Okay, I'm not covered by this. Fine. I'm curious. Just go for it.
You're more than apt to be able to go and make those changes, and then we wouldn't have an issue with the non-dissemination order at all. So I don't think that's, so obviously the 9th, I'd like to keep the 9th because my issues are very small and narrow regarding the non-dissemination order. But if you were to make changes to those ahead of time that I was able to review and it was acceptable, I would withdraw my motion, Your Honor.
Oh, so if it's moot, he'll withdraw.
Thank you.
Okay, that's fair.
It would be highly unlikely for me to change the order before I hear from counsel. Because I don't want to,
Here's what the court just said. The court just said, essentially, I'm in charge now, Phasma. This is my gag order now. It is followed along with the case. I am disinclined to acquiesce to your request to change anything about this gag order until I hear everyone's motions for oral argument. So the court's not going to shift anything on this gag order till there's oral argument.
3rd,
Aye.
4th, 5th, 6th. I only want to do this once. And I'm happy to set it for June 9th, maybe 10:30. Does that work for you?
That does, Your Honor.
Okay. Does that work for you, Mr. Rudley?
Yes, Your Honor, it does.
Okay. Mr. Logston?
June
Make it work,
9th,
Judge.
Okay. Let's do that in person.
in person,
Okay. So
hearing on the
now we
motions.
have the June
I'll have to
9th
summarize
to
those again.
10:30. We also have the Associated Press et al. On June 27th at 1:30. I assume that works for you, Mr. Rudley?
It does, Your Honor.
Okay.
Yes, Your Honor.
Okay, excellent.
Your Honor, may I speak?
Yes, Mr. Corona.
Your Honor, I apologize, I may have misunderstood what you said earlier. I was understanding that the week of June 26th was when the court was first available, but if the court is available to hear our motion earlier, we would be available on June 9th as well.
Oh,
I
do
know
it all
that
together.
Our most recent motion is pending more recently.
We're not done yet.
Obviously, we've been challenging this since February as well.
I'll explain.
And it's our position that the non-dissemination order violates the Associated Press.
Yes,
Media
yes, yes.
Coalition's First Amendment rights. Those constitutional violations are irreparable, so we would like our motion
Yes, yes,
to
yes,
be heard
yes,
as
yes.
soon as possible as well. If I suggested otherwise by agreeing with the week of the 26th, that was simply because I misunderstood that was when the court was.
He's like,
first
let us hear it
available.
June 9th too.
Thank you. Only one thing I'll say about that. Irreparable harm goes both ways. And so I was a little bit
Really?
troubled by that claim without considering the Sixth Amendment considerations. I mean, this is a balancing. The law is clear on this. Okay? It's a balancing test.
Ooh.
And when your client says
Judge
that
has
it's,
thoughts.
Arguing it as the First Amendment is absolute is also
So
troubling.
is the Sixth Amendment.
So I would suggest that maybe the Associated Press needs to
Chill.
tone it down, just ratchet down a little bit.
Woo!
Because some of the
Okay.
arguments, including the first line in the motion to intervene, says that the Supreme Court held a certain thing.
That's not what they did.
That I do not think that is what the court held. And you know the difference in a holding of an appellate court. So I just felt obligated to
Bring
help
the
you
spice.
out a little bit in terms of what the Associated Press is.
This lawyer's face right now. The court's like, I need you to calm the fuck down. And this lawyer's face is like, Your Honor, seriously, this judge is like, this is spicy. This is court spicy. This is Judge bringing the judge sass. Spicy. This is court level spicy. He's just tone it down. I'm troubled by your argument, counsel, is not something you want to hear the court say. I want to see if the lawyer pushes back.
Asking for. And in the meantime, there's a lot of potential irreparable harm from media that is affecting a fair trial.
What have they done so far?
That is really concerning.
What?
This is a very high-profile case. So I'm happy to set this on June 9th, too. Okay. How about we set yours at 1:30, though, so we don't kind of push them all together. Does that work for you, Mr. Rudley?
It does, Your Honor.
We're going to be here all
Does that work
day.
for you, Mr. Logston?
Mayor, I don't know if we'll have an evidentiary presentation ready by the 9th. That would be my only concern. We can certainly try, but
Well, let's see, and if that doesn't work out for you, then
we'll let you know.
we'll talk about it. Okay, I just felt the obligation to talk about irreparable harm. Okay, there's a lot of interest here, Mr. Carone, and I think my job, my constitutional responsibility is to consider all of the potential irreparable harms, or all the injuries, or all the harms.
The judge is going to tell you exactly how he feels.
You know, I just want, maybe it's appropriate, I was just thinking, you know.
Okay, we're going to get into the judge's stream of consciousness in just a second. Here's the vibe. I am disinclined to fuck with this gag order, so you need to tone down your language that the media is being irreparably harmed by not getting your clicks and views, because my concern here is the defendant's right to a fair trial, and the media can cause the irreparable harm that you say the court is causing to you. So you better come correct when we do this motion. This judge seems to be a big fan, my opinion, of this gag order, and is not inclined to go quietly with this gag order. I don't think, when the judge is concerned about the strength of the language of the motion, that we are going to see a judge who is not going to back the previous judge's gag order. I don't think we'll see much changed. Maybe we will see clarification with regard to the victims' families, but I don't think we are going to see the judge do much in the way of moving towards the media's motion. I think we might get a little movement on the motion for the victims' families. The judge is like, judge, the name's so nice you say it twice. I am not the judge. I am his honorable judge. I am judge. And I am not really worried about the media's irreparable harm. He has made it very clear where he stands on all of this. Woo-hoo-hoo. All right, Judge.
I just want to remind everybody, okay, on this particular
It's
issue,
like, as
all
I said,
issues, at all times, that we all, okay, judges, lawyers, journalists, media generally, have constitutional responsibilities to both the First Amendment and the Sixth Amendment.
Yep.
And what I generally am seeing in the newspaper and the media is no discussion about the importance of the Sixth Amendment. It's just the First Amendment.
Your Honor.
Which is very important.
Yeah, it's their argument.
But here's the real reminder. The first sentence of the preamble of the Idaho Rules of Professional Conduct says that a lawyer...
The Idaho Rules of Professional Conduct do not apply to the Associated Press, however, Your Honor, I'm just saying.
As a member of the legal profession, is a representative of clients, an officer of the legal system, and a public citizen having special responsibility for the quality of justice. We all have that responsibility. And sometimes we push in a hard way for our clients, and that's appropriate. But you have larger responsibilities at the same time.
It seems that he's talking more now.
Okay, so we got a hearing
to the victim's family's
10:30.
lawyer.
That's for the Goncalves family with Mr. Gray. 1:30 is the Associated Press et al. With Mr. Carone.
It's going to be an interesting day.
And
oh, he's not playing at all.
I think that deals with all the pending motions. For you, Mr. Gray, you are articulating what...
Let's talk about cameras in the courtroom then.
So we've addressed that, correct?
Thank you, Your Honor. Yes,
Okay.
yes, Your Honor.
You're welcome. And Mr. Carone, those two issues that are still outliers on your clients, I think that's all we have. The motion to vacate the amended non-dissemination order and the motion to intervene. Anything else that we need to address for your clients, Mr. Carone?
No, Your Honor, unless you mentioned the broadcasting issue as well.
No, Your Honor, unless. Well, then that's not a no.
not sure if you're going to set a separate briefing schedule for that. Obviously, for the motions, they'll follow the normal.
Let's talk about the cameras.
Motions are going to follow that. I just didn't know
Yes.
when exactly you want to have review.
I'm going to send a briefing schedule out for everybody. And now, okay, if we're going to do it on June 9th, you don't have very much time to do those briefs. So that's why I was thinking it made a lot more sense to do it at the end of June.
Oh,
But
Judge, they're ready.
if you all think you're ready to do that, I'm willing to hear it.
They're ready.
But I want those briefs.
Legal
We'll
briefs.
say
Those types
by
of
June
briefs.
2nd.
That's fast.
Response briefs will be due
I'll
by
be covering
June 6th, and any reply briefs due by June 8th. So that's going to be rapid briefing.
Rapid fire briefing schedule.
Just trying to accommodate everybody. Okay? I got a lot of interest floating around on these issues. Without forgetting Mr. Kohberger, who's primary in this case right now. All right, so
And that's
let's move
exactly what it
to-
is.
And I mean, anybody who's here for Associated Press or Goncalves family can be excused if you'd like. We're also happy to have you stay.
Because there's a scheduling hearing.
Thank you, Your Honor.
Okay, thank you.
There is now a scheduling
Okay,
hearing.
thank you, Mr. Farrell.
So he dismissed the attorneys
All right.
for the
So,
last set of motions,
What
and
we
now it's a
have
further scheduling
now
hearing.
between the parties is
On the
motion to
Compel.
which we're moving out. That was kind of a
Ann Taylor
on
looked
and
pleased
off,
with that result.
Hearing disclosures of grand jury materials while protecting those materials from the public. Extension time to file pre-trial motions after receiving materials from grand jury. I believe those are the motions that we have outstanding. Is this, are you arguing these or?
What the court just said, and now I'm going to do a quick swoop because we're going to get to the motions to compel, and we have not seen all these motions to compel. The court is moving on to the motions to compel between the defense and the prosecution. We have not seen all of these motions to compel filed. A lot of these, I am sure, have been filed under seal. What the court has just told us is that some of these are related to the pre-trial briefing schedule and the disclosure of grand jury information to the defense. So that is what we are going to be talking about in court now. When will things be compelled? When will future motions be due? So that is what it is. A grocery Greek. The defense attorney's name is Ann Taylor. The female defense attorney's name is Ann Taylor. The blonde defense attorney, I forget the name of the other defense attorney. He's newer. And then the judge's name is John Judge. So we have John Judge, or Judge, and Ann Taylor. And then the prosecutor has a Santa beard. It's look, court is real life. You can't make up real life. So let's get into what's happening with these motions. This is a scheduling hearing. Some of this might be resolved. We'll see.
Scheduling these, Ms. Taylor?
Your Honor, we can schedule all of those hearings.
Okay, when do you want to do this?
Your Honor, I think that if the court has June 26th, we could do that. We will be ready to address that round of motions on June 26th.
Excellent.
Hopefully we'll see some of those motions filed if they're not completely under seal, but it seems like a lot of them are under seal.
Well, how about 1:30 on June 27, because the Associated Press moved that to the 9th.
June 27th is just fine for us. Right?
Okay, perfect. Pull up 1:30. Okay. Is there anything else we need to address today, Mr. Rudley? Mr. Thompson?
Your Honor, I think the June 27th should work fine. For whatever reason, our office hasn't seen copies of the grand jury pretrial motions, but I think there was a miscommunication. Those will be coming. We'll be prepared.
Okay.
We haven't
great.
seen those filed at
And
all.
certainly, if those issues are resolved between counsel, then we won't have to have a hearing.
Well,
Yes, sir.
maybe
Thank
maybe
you.
that's why we
Okay,
have not seen them.
So, anything else we need to address today, Ms. Taylor?
No, Your Honor, thank you.
Okay, thank you. Mr. Logston?
There, thank you.
Okay,
All right,
great. So I think
they're gonna adjourn.
Ms. Masseth has been observing on Zoom. I just wanted to identify her, and also Ms. Let's see. Oh, I guess Ms. Beatty is too. So anyway, there are other people on the Zoom, so thank you.
Okay.
Okay, anything else, Ben? No. Okay, thank you all.
Thank you,
We
Judge.
are adjourned. Okay.
Court is adjourned. All right, I'm gonna leave the feed up as Kohberger walks back for the second time today after hearings in court. They went through 5, technically, I think, hearings. We're gonna talk about that now. So let's do a swoop and a summary of what we just saw happen, and then I will get to your questions regarding what we just saw happen. And we'll be covering it the rest of this week. We'll be covering it the rest of this week. So don't worry. There's plenty of time to talk about it. But the audio is terrible, but also I think the reason the audio is terrible is because when we see trial coverage from the court TV pool cameras, they put the cameras in different spaces in the courtroom and they set up their own microphones. I think they are on the mic attached to their cameras today. They do not have mics running around the courtroom like they do when they set up for trial. So hopefully it will be better, but I don't know. Let's do a quick summary. Today, we have had the Bryan Kohberger arraignment where he did not plea. He stood in silence, which is a procedure in Idaho that allowed the court to enter a not guilty plea on his behalf, and a trial date was set for October 2nd. Do I think that date could get pushed? Yes. Do I think we could down the road see Bryan Kohberger's attorneys waive time for speedy trial given the amount of discovery in this case? Yes, that could happen. But for now, the trial date is set for October 2nd. A whole lot can happen between now and then. But he has not waived his right to a speedy trial, which means it has to start within 6 months of the grand jury indictment last week. Then we saw a number of scheduling hearings with the court. First, scheduling hearings for the Associated Press motion regarding the gag order, for the Goncalves family attorney and their motion with regard to the gag order. Then with regard to a number of defense motions, for scheduling for pretrial and a motion to compel. With regard to the media and Goncalves family motions with the gag order, those are going to be heard on June 9th, which means there will be argument on June 9th. The court advised the media to perhaps tone down their language, slow their roll, if you will, with regard to their motions for the yeeting of the gag order. They're asking the court to get rid of the gag order. I don't think that's going to happen after hearing this court address it and telling them to slow their roll. Will we see them file anything else? I don't know. Maybe we will see an updated motion. Maybe we will just hear updated argument. Fine. The Goncalves family is asking for something different than the media. They're asking for guidance, which the court doesn't often give guidance. The court normally says, this is the order. Call really the Bar Association. Look at the rules of professional conduct and figure it out from there. But that is what they are asking for. They're asking the order be modified so that the victim's family can speak without violating the court order, so that this attorney feels that he can make statements on behalf of the family without violating the court order. But we also saw the family make a statement today. So are they terribly worried about it? I don't know. Their family made a statement today. either way. And maybe they were waiting to see if the court would say anything about it. The court didn't. Then we will see hearings with regard to the motions to compel. The court titled those as motions to compel information from the grand jury and disclosure of the grand jury. Those motions to compel means the court is going to tell the prosecution, turn this over in this amount of time. The prosecution has to turn it over either way. There might be a timing in Idaho that the defense wants to make sure that the court gets out ahead of it and says, here you go, compelled, turned over, and that's what it is. We have not seen those motions pop up yet on the motions docket from the court. The prosecution says they do not have copies of those motions yet, but the motion hearing was set on May 19th, but we didn't see the motions. The motions might be under seal. There's a lot that happens on this docket that we cannot publicly see, that is not publicly available. Idaho has locked things down more than any other jurisdiction that I have covered on this channel. They really have been close to the cuff with everything. We also heard the court raise the question of cameras in the courtroom, which indicated to me that the court was inclined to hear argument about whether they want cameras in the courtroom, don't want cameras in the courtroom, how it is going to be. So the court was giving the attorney for the AP the heads up that that is going to be discussed with the prosecution and the defense, and giving them the opportunity to have a comment or to know that that's coming up. And that's going to be discussed on June 9th as well. The court split the motions. So the June 9th motions will be a morning and an afternoon hearing, one for the Goncalves family, one for the AP. And I imagine we're going to see those aired the way we saw it today. The hearings will happen, the hearings will be recorded, and then those recordings will be disseminated to media stations after the fact. That seems to be what is going to happen, at least for June 9th. And then we will see if they argue something else should happen. So June 9th is our next day in Idaho. There are other live hearings coming up in cases. There are other trials that I'm keeping an eye on when they're going to go to trial. But for the summer, I think we might have a little bit, dare I say it, a little bit of free time, maybe, to get caught back up on cases that I've been needing to get caught up on. Let's talk about the schedule for the week, and then we're going to answer some more questions. I am going to stream tomorrow at my normal time. I have a new podcast for you on Wednesday. I may stream on Wednesday. If I need to take a look, if I'm going to stream on Wednesday, tomorrow will be a bit of a shorter stream. I am not streaming on Thursday, and then I will not be streaming on Friday. So I will be off Thursday through the weekend to go run around, Nashville with friends. So that's what I'm going to be doing. If any of you are going to be in Nashville on Friday for Dave, I will be running around Nashville. I will post on social. If we are going to be places where you can all come do the things, I will let you know. We are going to run around. If you see me, please say hi. We will take a picture. It will be fun. No judgment. I will be dancing. I will be singing. There are songs off the new album I very much want to see live. So I am ready. I would love to see The Maker. He's been playing The Maker a little. Well, there's only a few stops. I mean, technically it was just the beginning of the summer tour, but he's been playing The Maker a little bit. I have not seen it live in like 100 million years. I have seen Dave live since, I think my first live show was 1996. So I am ready. Oh, that's right. The Sarah Boone trial is in June. I will need to take a look at the dates on that. And if it bumps, things can bump. Things happen. So let's get to your questions. We are just at about 2.5 hours in. For all of you that are new, go ahead, do the likey, subscribey things. You guys have put us at the top of live streaming today. We have been the most viewed channel covering the Kohberger case. I love it so much. Thank you, Law Nerds, for making this the best place to watch trial coverage on the interwebs. Why? Because of you. It's because of you. I mean, y'all are the greatest. Everybody wants to be in this chat. Well, because it's so good. Because it's so good. You guys are great. So thank you so much. thank you so much for supporting me, supporting the channel. And yes, subscribing does help on YouTube, liking, commenting, all of that stuff. Yes, the algorithm is just pleased when you do the things. And so am I, so thank you. Let's get to questions. I've got questions, you've got questions. It's time to fack around. Feel like on the second screen I'm looking that way. My hair has gone very flat today. The weather's not a thing. We're gonna have to zhuzh. I was at the orthodontist this morning. Like it's just been a day. So with the second screen, there's times I feel like I'm looking like this way too much. So am I tempted to redo my entire office layout? I am. Oh my God. In the play button, you guys can see the chat rolling along. Look at that. Hold on. This is your chat. This is the chat in the background of the play button. That is so silly that I can see the chat scrolling. I might have to figure that out. Emily, are you tempted to buy all new monitors and do something else with your layout? Sometimes I am. You all are like, Emily, we don't need to hear about you rearranging your office, but you do. I mean, you're a part of it. I always want to feel like I'm looking at you. So that's a part of it. And when I'm reading questions over there, I don't feel like I'm looking at y'all. All right, let's get to questions. That was probably too much. Emily, more info than we needed. Yeah, probably. All right, let's get to Q&A for sure. That one, I clicked on it and then it clicked off of it. Yes. Do you know what happens when the defendant leaks case documents to a lawyer? So much drama in LA court last week. Love LawTube. I have not covered what's going on in the Masterson case. I think the jury is still out. I will have to take a look. But it's interesting seeing the discovery stuff that has been going on in the Masterson case. I don't know what the court will do with that. Stand silent is frequently used here in Idaho. Thanks, Kathy. Again, if it is a common procedure in Idaho, again, when I say each jurisdiction is different, all jurisdictions have their own quirks. Look, the way I was confused during jury selection in South Carolina, when the jurors had to stand in front of the counsel table and then be like, deal or no deal, was so the way I would have anxiety having to walk up in front of the juries and the attorneys and the defendant and look at them while they either like thumbs up or thumbs down. It was such a strange procedure to me. I was like, what is that? But this is why I really enjoy covering cases in all different jurisdictions. I've only worked in the jurisdictions I've worked in. I love seeing how different jurisdictions do it. Every jurisdiction has their own legal history and their own legal procedures and legacy. And that's an interesting thing for me. I really enjoy following it along with all of y'all. So that's why I will always say I will default. And I don't wear makeup. Okay, I bought the lip gloss. Great. Now hubby expects me to wear it. Just try it. Just try it. You don't have to wear it long. Just try it and see how you like it. Alligator surfing, the more you know. Alligator surfing was interesting today. It was I don't know what just happened here. There we go. What's the status of getting your own feeds? We are working on it. It is a thing that has to be done. Alligator surfing reminded me of California classed bees as fish. I have no idea that California classed bees as fish, but okay. I'm getting some slowdown today. I lost a super chat there, and I am so sorry that I did. I was trying to pull it up, and it just completely got yeeted. Apologies on that. I do not know where it went, and I do not still see it up. Sorry about that. It clicked on and clicked off. I don't know what that was. So apologies to the one that flashed and then disappeared. I work in legal tech and this hearing is giving work PTSD. Zoom is hard. Is there any chance, I don't know why these are slowing down today. Is there a strong chance we won't get cameras in the courtroom? I want to hear what the judge has to say more. I think this judge is trying to balance the two, but I think that balance, I don't know why these are popping down by themselves. I don't think that balance is going to weigh in favor of the media based on this court. Let's see. Hey, Emily, the Murdaugh trials spoiled us. I was following the Daybell Staunch trials, and I have to say South Carolina is the best to watch live, missing Judge Newman, Creighton, and even Dick and Jim. The Murdaugh trial was an interesting thing on its own. The way that the court ran in Virginia was also very smooth. I really appreciated it. So we've seen some really smooth courts. The audio today was really tough, and that's not uncommon. There are some courts that the audio has just been like, what? Do you think you'll cover the Egypt versus Netflix Cleopatra situation? I don't even know what that is. I'm just like now mad at my hair because it is weathered. I have no idea what that is. I love covering a Netflix situation, though. We need to circle back to the Queen's Gambit lawsuit. I don't think that one's done. So, could the judge be sticking with the gag order to prevent prejudice in the jury pool? Yes. Yes, that is a very real possibility. We will see what the judge decides to do. What does motion to compel mean? It means they are asking the court to force the other side to do something, but we haven't gotten to see those yet, so I can't give you the full rundown. Kim said my lip gloss just arrived in the mail. Yay, I love it. The box is my favorite kind of box ever. The lip gloss feels great and it smells good. No one ever mentioned that it smells really good. I'm so glad you are enjoying it, Kim. Aren't they great? Question. When are you going to be in Texas? As I know more about my travels to Texas, I will let y'all know. For now, my flights aren't booked, so things aren't set. Question, do you think the AP lawyers should tailor their arguments to how an open court and transparency benefits the defendant, not just the First Amendment? Not really, because that's not their interest. Their interest is in their First Amendment rights. So that's what they're really going to focus on, is on their rights. The defendant's rights are not their rights. Adam said, is his name actually Judge? Yes. Judge. I'm delighted by it. Yep. Question, Emily, have you seen the new Advent Aldi released for Cuthbert the Caterpillar? No. Oh, the advert. I've seen the advert. I covered it live on stream. When did I cover it live on stream? A little bit ago, but I did. Question, has there ever been an alligator lawyer on Zoom? Not that I've seen, but if it has happened, I would love to be tagged in it. I love it. Question, what effect does something such as the 4th of July have on court scheduling? There is no court on the 4th of July, so those holidays get avoided. The 4th of July also, well, in California, used to bring in a ton of new cases. So judges tend to keep, especially courts that deal with arraignments, tend to keep the following week light on things that they schedule because there tend to be a lot of arraignments, especially depending on the level of court and the location. So a location like California where fireworks are illegal, there are a ton of fireworks cases after the 4th of July, or there used to be. DUI cases, things like that, like drunken disorderlies. So misdemeanor courts would be busy. So courts would schedule light, going, okay, well, these days after the 4th of July holiday are going to be busy. These days after Christmas are going to be busy, et cetera, et cetera. So courts generally will look at 3 or 4 months at a time to schedule out what they are doing. And that is one of the things they look at. So we already added a rabbit hole with Chippendales last week. The Chippendales rabbit hole was a great rabbit hole, and I stand by that. Also, if you guys haven't checked out the Quick Bits for this week, I cover that in Quick Bits. Quick Bits is like under 10 minutes this week. So Allie said, where can I check out these lip glosses? There is a link in the description. Nightbot has a link. And the mods have put the link in. So Chelsea has also put the link and all of the information that you need. Anise in the chat said, I hope cameras are allowed. Agreed. Because I think covering it the way I do, I mean, yes, I could go sit in court and tell you what I think. I don't know if that's the best use of my time. Yes, there are reporters in the courtroom telling you what they think and giving you a sense of it, but seeing what the judge says, how the judge says it, what the attorneys say, how they say it, those things I think are really important. And every time you get somebody else's reporting on that, it is filtered through what they heard and what's important to them. What's important to traditional news media isn't always the things that I'm going to pick up on as number one as an attorney. So the news media kind of picks up on what are the news headline things. I'm terrible at that. I don't know what the news headline things are. I know what I'm interested in. legally speaking. And what I'm really interested in this is that this judge told the AP that they need to check themselves before they wreck themselves in toning down their language, that they are being caused irreparable harm. So we heard the judge say, look, you need to dial it back. And it wasn't just one sentence. And Brian Enton did tweet those things out, but the judge went on about it for a little bit longer, which makes it seem to me that the judge believes that this gag order is a good thing and is unlikely to change it in a substantial or significant way. And that there will be, my opinion, that there will be a gag order in some form in this case going forward. Sorry, but I think there will be. Truly, I think there will be. Let's see. In England, I believe the courts all singing off the same song sheet regarding the law. So confusing. In the US, have all different laws and procedures. So this is fair. So in the US, we have state courts and federal courts. So we start with two different court systems, right? Because we have the state level courts, the federal level courts. Then within the state level court system, they are broken down by different jurisdictions. So like in LA, it's county. In some places, they call counties different things. So it's by different jurisdictions. So they are broken down sometimes by circuits, sometimes by counties, sometimes by whatever they call them in New Jersey that is escaping me at the moment. And so then they get broken down further state by state, and each of those courts has local rules. So the rules in Los Angeles County are going to be different than the rules in Fresno. Parishes, yes, like Louisiana. So even with it, yes, townships for Jersey. Thank you, chat. So even within the state, the way you do something in San Diego court is going to be different than Orange County court, is going to be different than LA County court. There are local rules to all of those courts. So they are highly specific based on where you're practicing. And sometimes there's overlap and sometimes there's not on the types of things that they deal with. So our legal system is highly complex and very confusing. Trying to navigate it, yes, in some places Commonwealth, trying to navigate it is not easy, particularly if you're not an attorney. And sometimes, depending on the law school you go to, you will deal with the regional things, but then if you move somewhere else to practice, you will need someone that practices in that area to help, which is why we see like the pro hoc vice practice, where you have to have like a buddy lawyer in the jurisdiction to work with you when you pro hoc vice in, because the local rules are so different. Now, yes, you can look them up, but you also need to know the ins and outs of the quirks of each individual court. So you will see if there is an attorney that is not licensed in the state of Washington, they are licensed in the state of California, they will get a pro hoc vice attorney in the other jurisdiction to navigate local rules. But the laws are generally the same. Like a burglary in California is generally going to be the same as a burglary in Massachusetts. The case law might be a little bit different. The way that you say the elements of the crime might be a little bit different, but it's generally going to be the same thing. The way that you look at a homicide in California is stated on an information a little bit differently than the way it's stated on an indictment in South Carolina, which is a little bit different than the way it's stated on an indictment in Idaho. But the underlying crime is basically the same. So, with all of that, it is very confusing. I agree. It was a really long way to say that's confusing. I agree. I saw you on our TV in the UK last night. Depp versus Amber Heard documentary was so strange. I have not seen it. If it shows up on YouTube, I'm going to have to try to find it. So thank you. Question, do you like Judge's chair better than Judge Newman's chair? Not yet. I need to see it. I need to see it more, but it seemed very cool. When you're in a Zoom meeting and a participant says, hey, is that Emily you're watching back there? Jennifer Home. I'm so glad that the Zoom was all in agreement that this is where we should be today. Julia asked, Idaho Supreme Court, U.S. Supreme Court. I have a bunch of videos covering what happened in the Idaho Supreme Court. I have a playlist for Idaho on the channel if you want to go catch up, but the Idaho Supreme Court. Oh, yes, I've been waiting for food court to do this. Yes, I have. Gosh, y'all are going to make me want Taco Bell for lunch. I'm not blaming you for the urge to get fast food. It's totally on me. Anne said, I filled out an okay grand jury form for possible jury duty. I'm nervous and a little excited to see if I ever get called in. How does that work? Do you know? Every jurisdiction is different, but they will call you for jury duty similar to the way they always call you for jury duty. I would look at the rules in Oklahoma and see if they call you for 1 day a month, for 1 week, for 1 day a month, for 6 months. It should say on your local court website. It's also, you need to check and see if you are signing up for Oklahoma federal grand jury duty or state grand jury duty, because there are two. I think federal grand jury duty could be more interesting because they tend to bring bigger cases, like larger crime schemes and stuff. They have more resources. I know, chat, now I want tacos. Damn it. I'm going to have to go get tacos. Then I need to record the podcast, but I'm going to have to go get tacos. I think I have time to get tacos. I totally have time to get tacos. Y'all, my phone is binging me about tacos. It's listening to me. Just ordered my lip gloss. Can't wait. We'll wear them with my I Have Questions tea. Thanks for making law fun. I am here to make law fun and hopefully to demystify it a bit. There is a lot that can be confusing. I think we need to not gatekeep legal understanding behind hundreds of thousands of dollars and massive amounts of debt, right? It's kind of bullshit to me. I want to help y'all understand how this works. And I also want to make sure that when you see something going on in the proceeding, like the judge saying, you know, the focus here is on the defendant's rights, y'all aren't going, this judge is biased. You guys wouldn't because you're law nerds, but the internet in general, no, this is the judge's focus. The judge's focus is not on the clicks and views for the media. The judge's focus is on protecting this case, this defendant's rights, this trial. And protecting that trial benefits everyone. And then balancing that with the public's right to know and how you balance that. And I think that's really important. And I think we heard this judge talk about it. Yeah, I think we heard the judge talk about it. So in the chat, Eva PA just said, wait, where did it go? I want to grab it and pull it up on screen. Oh, I lost it. There's a lot of y'all in the chat, and it just wait, where did it go? There it is. Thank you, Miguelina. I think you grabbed that for me. My third grader loves the song. It's raining tacos. It's raining tacos out of the sky. Yes. My fourth grader has loved raining tacos for some time. I might go get tacos before Dr. B even gets home. Don't tell him. Crew Kid 52. Hey, Emily, been a fan for a long time. Thank you. Really started following you during Johnny Depp, Amber Heard. Can you believe that was a year ago? Love your community. Me too. Aren't y'all the best? You're hydrated. You have healthy boundaries. You're good drivers. Y'all are fashionable. You woke up like this. I love y'all. Also started a new job at a law firm as a file clerk 3 weeks ago tomorrow. Congratulations. I hope you are enjoying it. Here's the way to make yourself invaluable at a law firm. Help them fix the tech. Help them fix the tech. So Chada, I'm going to pronounce this badly. Question, why did the gag order? I covered their motions last week. They want clarification on the ability to speak to the media and the ability to make statements on behalf of the family. They want to be heard and are fighting to make sure that the gag order doesn't restrict them, which I think the gag order covering non-witnesses goes a little bit too far, but they are trying to be careful. And I appreciate that. So Troublemaker Baker says, I make a pretty amazing grilled fajita taco. So good. Y'all can make tacos. Look at you. Talented. Mariko, question, could Kohberger gag order tangentially help that professor in the TikTok suit? Not really. I mean, this all started when the professor was defamed. That all started when the professor was defamed. Do I think the gag order will help? No, because the gag order doesn't cover the TikToker or the professor or anyone else who's inclined to wild out. With all of that, chat, it has been almost 3 hours of streaming. I am streaming again tomorrow. It'll be a little bit more, it'll be a little shorter because I might I'm going to go look at what to expect in the Petito laundry case on Wednesday. I might want to cover that court hearing on Wednesday. I'm very interested in what's going on in that case, and I'm torn. The members will know when I do a behind the scenes recording of the podcast today what I'm covering. I have two topics that I am torn on for covering, either catching up on the Petito case before that hearing or catching up on what's going on with the Natalie Holloway Vandersloot extradition and what's going on there. Like, there's two things and I'm like, what do we cover? I'm going to cover them both, but what do I cover first? So both of them criminal cases, both of them disappearance cases. Maybe I make it short and cover both. Can I do that? I don't think I can do. I can never make anything. I can never make anything short. So, members, you will get to know, and I will see what we do on Wednesday. So thank you all for being here. I might cover that hearing on Wednesday. I'm real curious. But I might also cover it next week. We'll see what time it's at. I will keep you posted. Look, if you want to know what I'm doing, you just need to be on Law Nerds Alert. If I told you to join our email list, that is how I can keep you in the loop the best. All right. 2 more and I am wrapping up. I am not going to be able to get to anything else, so this is it. Gave my hearsay lip gloss to my law Greek grand. She plans to be a lawyer, working her 9th to 12th grade to get her on her way. Amazing. Yay, lip gloss. Alan said New Jersey townships are just towns by another name. The main trial courts are county level. I know, I remember when jury duty was 2 weeks, I sat on 4 cases. That was fascinating and a lot of jurisdictions did this and have shifted. Now, like California is one day or one trial, but you used to get a block of time for jury duty and just do case after case after case after case, which I think would be fascinating too. That's more like the grand jury. So with all of it, Law Nerds, thank you for being here. We didn't even roll an intro today. We just got into it. So we're going to roll the outro. I will keep you in the loop on where I will be on TV this evening. And with that, thank y'all for making this the best place to see trials, because y'all are the best. Cheers. Stay hydrated, friends. I need to go get tacos. I'm going to go get tacos and contemplate what I'm doing for the podcast. That's exactly what's happening. All right. Bye. It's not rolling. You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at the Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.